Welcome to our second day of our spring oral argument session here in Pittsburgh. Before I give some introductory remarks, I'd like to welcome some students who are visiting with us today. First of all, we have high school students from my alma mater, Lincoln High School in Elwood City. These students are part of the U.S. AP Government and Politics class at Lincoln High School, and they're here with their teachers, Mr. David Gabus and Ms. Jolene Krupa. Would the students stand so we can see where you are? Welcome to the Supreme Court. I hope some of you will become lawyers after hearing these arguments. You can be seated. The group includes Grady Smith, who is the student who won our statewide essay competition in celebration of our 300th anniversary. So congratulations again to Grady. Visiting with us also, we have Adjunct Professor Aaron Walayet, along with his students from Pitt Law, and they are students from his state constitutional law class. So would you all stand? Welcome to you all. Thank you. As you all may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. You probably know that because we say it all the time. Our roots date back to 1684. To William Penn's provincial court, and the Supreme Court was formally established in 1722 pursuant to the Judiciary Act of 1722, and last year we did celebrate our 300th anniversary in Philadelphia. We're sitting today in Pittsburgh City County Building, a 1917 granite Art Deco building which was designed by renowned local architect Henry Hornbostel. The building is next door to our beautiful county courthouse, and it was designed to complement the courthouse, but not in any way to mirror it. The city-county building houses executive, legislative, and judicial offices for both the city of Pittsburgh and Allegheny County. Architect Edward B. Lee was responsible for the design of this magnificent courtroom. The wooden oblongs, the fluted columns, and the bench and bar are all mahogany. Behind the bench is a beautiful mural of the state's coat of arms. That same coat of arms is carved into the justices' chairs, and individual elements are represented in wood medallions on the bench. Specifically, a ship carrying the state's commerce to the world, a plow working our rich natural resources, 3 golden sheaves of wheat representing our state's fertile fields and our citizens' wealth of human thought and action. And finally, an American bald eagle demonstrating Pennsylvania's loyalty to the United States. If you look up, you'll see the murals in this room. They were painted by local artist Edward Trumbull, and our ceiling contains murals of 3 great lawgivers, They're framed by gilded plaster, and furthest from the bench, you will see the Byzantine Emperor Justinian, famed for the Reformation and codification of Roman law. In the center is Moses, seated and holding the 10 Commandments. And finally, closest to the bench is the English King Edward I, who spent much of his reign reforming the common law. To the left of the bench, you will see a mural depicting William Penn, founder of Pennsylvania, and to the right, William Pitt, the first Earl of Chatham, who was held in high esteem by the American colonists after supporting many of their positions. The city of Pittsburgh is the namesake of William Pitt. It's truly an honor for us on the Supreme Court to sit and work in 3 beautiful courtrooms in Philadelphia, Harrisburg, and Pittsburgh. Before we hear the first case, I'd like to remind counsel of just a few things. Appellant counsel, when your case is called, please approach the podium. I will then give a short summary of your case, and then you may begin by stating your name and the party you represent, and by introducing your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, you should avoid repeating the same argument as the prior counsel. Please try not to interrupt the justices when they're asking a question. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues we would like to explore further. While there's no set time limit for argument in our courtroom, I will advise counsel when the court is satisfied that all of their questions have been answered, and at that time I will ask that you conclude your argument. Mr. Minner, would you call the first case?
Greenwood Gaming and Entertainment versus the Commonwealth of Pennsylvania Department of Revenue. Representing Greenwood Gaming, Mr. Adam Scheinhold. Representing the Department of Revenue, Mr. Michael Scrinsky.
Thank you. In 2017, the General Assembly enacted Act 42, which authorized online gaming in our Commonwealth, including iLottery games offered by the Pennsylvania Lottery. While Act 42 permits the state lottery to offer various internet instant games, the Act specifically precludes the lottery from offering lottery games which simulate casino-style lottery games, including slot machines. In this appeal by certain casinos, we review the Commonwealth Court's determination that the internet instant games currently offered by the state lottery do not simulate slot machines in violation of Act 42. Good morning.
Good morning, Madam Chief Justice. Thank you. Adam Scheinvold on behalf of Appellants, Greenwood Gaming, Chester Downs, and Mountain View Thoroughbred Racing Association. I'm here this morning with my colleague, Carolyn Bochek.
Morning.
May it please the court. This case is about a state agency that is exceeding its statutory authority. Unlike other cases that have come before this court raising this issue, this case is about an agency that's actually a market competitor, a market participant, and an unregulated market participant. And this agency is failing to abide by the very specific limits that were placed on it by the General Assembly. And they're doing it without accountability. Here, that limit on authority is by offering games by the lottery that simulate casino-style lottery games. Despite the clear statutory prohibition, that's exactly what the state lottery did. They even offered a game that is an identical copy of a casino game that is offered just a half mile across the Delaware River in New Jersey as a slot game. When Volcano Eruption is played in New Jersey, it is a slot game offered by the Golden Nugget, requiring you to be 21 years old to play. It has to be certified by the New Jersey Gaming Commission. Yet, the Pennsylvania Lottery has offered that game in Pennsylvania and rebranded it as iLottery, and yet the Commonwealth Court nevertheless concluded that this does not simulate a casino-style lottery game. The Commonwealth Court, after several days of trial, fashioned a new statutory rule. The Commonwealth Court rewrote Act 42 in a way that contorts the language, the plain language of Act 42, and simply rewrites and writes out of existence the legislative intent that the lottery can't offer casino games while the casinos can't offer lottery games. Historically, no one ever confused the lottery with casinos. Although both are a form of wagering for entertainment, the product offerings were distinct. They operated in distinct forums. They had different rules. They looked different. They felt different. They had different prizes, different prize structures, different ways that they operated. Through the Pennsylvania lottery, adults over 18 could play draw games like Lotto or Powerball. They could play instant games like Scratchers. You go to the gas station, get a couple Scratchers. Or they could play the daily number games. At casinos, adults over 21 could play slots, roulette, blackjack, other table games, and poker. There was never any confusion.
May I ask you, counsel, and this may reflect my lack of knowledge of casinos, so I apologize in advance, but isn't there bound to be some similarity with games of chance, whether they're online for the lottery or in casinos, just because of the way the games are displayed, and that wouldn't necessarily mean that the iLottery games are simulating the casino games? Isn't there bound to be some similarity?
I suppose that if you take it back, you're going to find a similarity. There's a random nature to it. There's a drawing, in a sense, for many lottery games. There's an element of chance, because these are not skill-based games. They're random, or they're intended to be random anyway. So at a certain level, there's going to be a similarity, just like you can draw a similarity between a doctor and a lawyer. One doesn't simulate the other, but they're similar. They're professionals. They went to school for a long time. They both have advanced degrees, and they provide a professional service for a fee. So
These seem more similar to me by nature than a doctor and a lawyer, though. I mean, they appear to be similar. They would have to be in order to have this random game effect, wouldn't they?
No.
Spinning wheels and numbers popping up and not showing and then showing. That just seems inherent in games of chance.
But it's not, Your Honor. A game of chance is pick a card. That's a game of chance. That's wildly different than spin a wheel. That's also wildly different than pick numbers and see what comes up on the board, which is also wildly different than press a button and have a game display an outcome, which is also wildly different from wagering on sports. So to say that they are similar simply because they are displaying the outcome of a game of chance is boiling it down to a distinction that has no difference. So while the point is that they are all forms of wagering and wagering on a game of chance, beyond that, the differences and the distinctions are critical. And as we demonstrated at trial, the differences between lottery games, for example, Scratchers, instant games. These are printed rolls of tickets that are randomized. There's 1 million tickets printed. They're sold for $5 a piece. You can win a prize if you uncover a series of symbols that match whatever the rules are of that particular game. But that game is very different than, for example, a slot machine. Even though a slot machine is displaying symbols that will match or not match and result in a prize. The differences are enormous in how the game is played.
Counsel, can I ask if you could tell me in 100 words or less, joking, but if you can, what is your client's position on what iLottery games should look like, or what lottery games are permissible in your client's view?
iLottery games, I'm trying to count 100 words in my head. iLottery games.
You've already used several.
Yeah.
iLottery games are defined by statute.
I know that,
So
but what are
include-
they supposed to look like? I mean, I'm just trying to get my arms around what your client's position is. The Commonwealth Court found that what the iLottery could not do was use spinning reels or pay lines. Am I correct?
That's correct.
That's all.
That's correct.
Okay, so what's wrong with that holding?
there's two different questions in there. I'll address the first. iLottery games are intended to be digital representations of lottery games, lottery products. They are intended to include internet instant games, which, when understood as being distinct from interactive games, which is the statutory distinction made in Act 42, should be lottery-type games, meaning that they follow a form that is consistent with the digital representation of traditional lottery
Like
products.
scratch-off.
Like scratch-offs, for example.
Well, and the big difference there, too, to cut to the chase, is lottery games have a finite number of winners. And there's a predetermined number of winners of the batch of tickets that are created. Whereas slot machines, there's no predetermined number of winners. There's a regulated amount of payout that has to be done, but anybody could win, and one person's win does not risk the other person's ability to win.
That's absolutely correct. And now, there is
Isn't the key, just to follow up on the distinction, isn't the key that, from your perspective, that whether using the lottery law or the Gaming Act, the definition of the iLottery category has to be this reveal function. So again, analogizing to the scratch-off ticket, whereas the casino games are the interactive ones. Isn't that the distinction?
I think that's a distinction, Your Honor. The internet instant games, the definitions provided in Act 42 and the definition that preexists from the lottery law involve a reveal. There's no question, they reveal a symbol. The critical distinction that we are drawing is the form of the reveal, and on that particular element of the games. So to analogize to a scratch-off ticket, to a traditional instant win lottery ticket, you use a coin, you use a key, whatever, you scratch off the covering to remove it from the symbols, and then you look to see if you won. With a slot machine, there can only be a single interaction, by definition. You press a button, the screen animates, everything reveals all at once, and then you know your outcome. And with a lottery product, that's not what traditionally happens. So when you're talking about the reveal function, and this is particularly when included with all of the functions that were at issue in this case, you've got a sequence of actions that are only found in a slot machine and that have been incorporated into these iLottery games to distinguish them from traditional lottery products, which require this independent action by the user, which have a limited prize pool, which have a predetermined outcome at the time of game creation, as opposed to at the time of the interaction with the machine.
Could I stop you there, Mr. Steinbold, because I'm still not sure that you answered the question Justice Donahue posed, which was, how do you think the iLottery games could look not to violate the General Assembly's mandate?
The question is, there are certain games that are on the iLottery site that have been offered that do operate like a lottery game, for the most part. None of them have a predetermined outcome at the time of game creation. None of them have a finite prize pool or finite number of plays. All of them operate under the context that every prize is available on every play, just like a slot machine. But in terms of the game play, there are a couple of games that are on the iLottery program that play like a scratcher, that you have to check each box one at a time to reveal each symbol one at a time. You look to see if you won by comparing it to the prize chart. The game actually tells you automatically if you won because it's digital. It relieves us of some of that excitement of trying to compare the prize chart. But it doesn't have this autoplay feature. It doesn't have an adjustable bet feature. It doesn't have a reveal all feature. And it allows you to play the game like a scratcher. And that's, frankly, exactly what the testimony at trial showed.
Counsel, you're making this, I think you're making Justice Donahue's point because you still haven't answered her question.
I'm sorry.
The question is,
What can it look like?
what in your world definition of a proper iLottery game does an iLottery game look like? Don't tell us what they have. Don't tell us
Okay.
what a slot machine is. Tell us you're designing a lawful iLottery game. What does it look like?
A digital representation of a scratcher.
Okay. That's a pretty straightforward answer.
Okay,
And I don't.
that's what I thought you were going to say, because then my follow-up question would be, why doesn't the statute say that the iLottery can replicate online the products that are now sold by the lottery at gas stations or wherever
The
it is?
statute doesn't say replicate. It doesn't compel it to do that. The statute is sufficiently open-ended to accommodate the new media.
That's very charitable of you. When you say it's, you've charitably characterized the legislature's handiwork. Sorry to interrupt.
It's rare to hear in this courtroom, isn't it? The fact is that the statute was designed and it was implemented on both the iLottery side and on the interactive gaming side to accommodate this new media, to allow lottery to function in a digital space, to allow the casinos to function in a digital space. And that requires some flexibility. That requires the lottery, for example, the lottery, you can't scratch off a ticket in a digital world. You can reveal a symbol in the digital world by clicking on it. So to say that what can it look like, frankly, that's the job of the Department of Revenue. They were charged with making regulations, and they didn't.
That's interesting that you would say that,
Yeah.
because I would have answered Justice Donahue's question a little bit differently. Because the issue in this, the real focus issue of this case is, are the games that you are challenging simulating slot machines? That's really what the issue is in front of us. The board regulations, the Game and Control Board regulations under the Horse Racing and Gaming Act, has a definition of slot machine.
Yes.
That definition of slot machine talks about anything approved by the board.
Correct.
So why isn't that the answer to Justice Donahue's question is, they can simulate anything that isn't approved by the board for use as a slot machine in a Pennsylvania casino. Everything else is fair game. But their games simulate what the board has decided are approved slot machines for use in Pennsylvania casinos. That's the problem.
I think, Your Honor, that captures most of it. The problem is that
Do their games that you have challenged in this suit simulate games that the board, the Game and Control Board, has approved as slot machines? Because if the board has defined them as slot machines, we're done. Because the board has the authority from the General Assembly to apply that act and define what slot machines are in Pennsylvania.
the answer to that is yes, but it's not as clean of a question, so it can't be answered that directly. Because, first of all, the statute says they can't simulate casino style. It doesn't say we can't simulate. It doesn't say they can't simulate a authorized slot machine. Second, a slot machine is defined as a device. So, which is the same problem that arose in other cases under the gaming law, that a device approved by the Gaming Control Board that has these other features is a slot machine. So a digital representation of a slot machine is not a slot machine. It's an interactive game, and the interactive games are approved. So what we're talking
Simulating, your whole lawsuit is they simulate slot machines.
they simulate slots and slot style games. Yes.
Right, but we have an agency that the General Assembly has granted the authority to regulate slot machines.
Yes.
And I just think this case is it seems to me it should have been a very simple case, which is, if maybe the Gaming Control Board should have been named a party. I don't know. Maybe somebody should have argued primary jurisdiction and transferred the matter to the Gaming Control Board to adjudicate whether the iLottery games are slot machines. I don't know. But all this evidence about Everything else seems to me to be ignoring the fact that there is this agency over here that decides what is and is not a slot machine in Pennsylvania. And if you bring in a whole bunch of approved games that are in Pennsylvania casinos where the board has said these are slot machines, and you compare it to the games you're challenging, and if there's a comparison, if what they're doing simulates what the board has said is a slot machine, game over, you win.
Yes, but what if they are simulating a game that is a slot machine that is not on a Pennsylvania gaming floor but is on a New Jersey gaming floor?
Well,
That was my
right,
question.
I agree with you, but that's your problem.
Well, it is our problem, but that's what we showed at trial. That is what we showed
So
at
you're
trial.
telling me that the games that you are challenging simulate New Jersey slot machines but don't simulate Pennsylvania slot
No,
machines?
we're saying they simulate slot machines, period. End of discussion. It is a casino-style game. A slot machine is a casino-style game.
That's your answer. The statute refers to casino-like, correct?
Casino style, yes.
Casino style,
Doesn't it further include within their slot machine?
including.
Specifically including slots, roulette, poker, blackjack. So
And
it
including
includes,
that-
it's broader than that. That's
Yeah,
the
can
that's
I
the
follow
point
up
here.
on that, because I think my colleagues have brought up something that's of interest here. It seems like there's a lot of focus on the word style, and I wonder, is the definition of style so greatly relevant? Because the statute says simulate casino-style lottery games, specifically including poker, roulette, slot machines, or blackjack. So isn't the question, does this thing have the look and feel of a slot machine?
Yes.
Isn't that what we should be focusing on rather than getting distracted with the word style?
Yes, Your Honor, and that is what the evidence at trial was designed to demonstrate, and it did. Frankly, as you could see from the evidence that's in the record, there's videos in the record, there's gameplay actually demonstrated in the trial court record that was presented to this court on review. These games are slot machines.
Well, is there evidence in the record of what slot machines the Gaming Control Board in Pennsylvania has approved for use in casinos?
We did not put into the record a list of slot machines that have been approved by the Gaming Control Board as compared to the names of the games that are played on iLottery. What we did is we demonstrated the mechanics of slot machines, the way that slot machines play, how they function, how the math behind the slot machine works, how the interaction with the player works, the look, feel, and player experience that is designed to do that, and then compared it to all of the iLottery games. All 58 of them that were available at the time of the trial were demonstrated, and that chart comparing all of those features and those statistics is in the record. It's Plaintiff's Exhibit 318, I believe,
So
and it's reproduced in our brief.
You confused me a little bit, because in response to Justice Brobson's inquiry, or I'm sorry, Justice Weck's inquiry, you agreed with him that we don't really have to focus on the word style. But your argument at trial was not that at all. I mean, your argument at trial was that the use of that term was an expansion, not a limitation, which is the way the trial court, the Commonwealth court, viewed style. So, I mean, is it, and you argue that you have to look at the totality of the experience, et cetera, et cetera. That, to me, was derived from your interpretation of the use of the phrase casino style. Am I incorrect?
I think you're not quite correct, because there's two issues on the statutory interpretation side and the way that applies to what was presented at trial. First, there's the issue of casino style. Casino style means in the manner of, or in the style of, or in the fashion of. The statute says casino-style lottery games, specifically including, and as this court has stated multiple times, when there's a list that begins with the word including, it's expansive. So we have two different linguistic expanders that are present in the same clause, which clearly should mean that it's not a limited list, and it's not intended to be narrowly construed, particularly because the legislature chose the words casino style, and casino is not a word that is found in the horse race development and gaming law. You have licensed facilities, you have gaming operators, you have certain types of games defined, but it doesn't say casinos.
It doesn't say
Casino is
gambling
common.
either, it says gaming.
Gaming, correct. Casino is not a defined term. Casino is a common term. It's a commonly understood term to mean a place where people go to gamble and a type of game that is typically found there. So it's a very expansive statutory definition. Now, in response to the other half of your question, Justice Donahue, is although I agreed with Justice Wecht, because I think his point is very salient, which is that the look and feel and player experience is critical to this. It is by no means limited to that, because while the features that we have objected to and have identified in all the evidence, the autoplay, the reveal all, the adjustable bet, the unlimited prize pool and non-depleting prize pool, and the bonus games, those are all the player experience. That's what makes a slot machine in Pennsylvania. That's what 98% of the slot machines on the gaming floors do.
But I want to understand your point on that. Let's say somehow, some way, the Gaming Control Board came in here and filed an amicus brief that says we've reviewed all the iLottery games and we don't believe that they are slot machines for purposes of Pennsylvania law. Do you still win because you're arguing this sort of casino-style argument, even though the Gaming Control Board has said, no, these aren't slot machines?
Absolutely, because they're not slot machines. They simulate slot machines.
What?
So you would still win? Is that how you're answering that question?
Absolutely.
Okay.
That would be a weird hypothetical to eventuate in reality, wouldn't it? I mean, the gaming board presumably would have the opposing interest, wouldn't they? Since
I don't think they would.
their budget is funded by the levies from the casinos.
But the lottery is not a licensed gaming operator, so it doesn't pay any taxes, so it doesn't fund the Gaming Control Board.
Right.
So the hypothetical is just that. It's hypothetical.
I don't know how you can simulate, but I don't know. And maybe I'm just being dense on this, and I've been dense before. But it just seems to me that Pennsylvania, we're talking about statutory interpretation. We're talking about the intent of the General Assembly, and
Yes.
I appreciate your candor on the definitions in the iLottery law and the gaming. I mean, there is an overlap, in my view, primarily because the General Assembly wanted to be flexible to develop these games, to point of your answer. But I'm just trying to figure out why, if the Gaming Control Board wouldn't or hasn't approved a slot machine in Pennsylvania, that these particular iLottery games simulate, why that wouldn't be the end of the inquiry. That wouldn't end the inquiry. Because you can't compare it as a simulation to any approved slot machine in Pennsylvania.
Because the Commonwealth Court said that the only thing that makes a slot machine a simulation of a slot machine is spinning reels and pay lines, and that's nonsense.
I know that's your argument. I'm just saying, why didn't she
proof
start?
wouldn't matter what we demonstrated.
Why didn't the Commonwealth Court just start from the premise? Here are all of the games that Pennsylvania Gaming Control Board has approved as slot machines in Pennsylvania, and the only question in front of me is, does what you're challenging simulate those?
I think that would be one way of doing it, but it's not. It can't be so limited, because first of all, slot machines are devices; they're physical. Second, because not every slot machine in existence has been approved for use in Pennsylvania.
But that's how the gaming law defines a slot machine in Pennsylvania.
That's correct, but it's also saying simulate a slot machine. It's not saying, and it's saying casino-style games, and it's saying including slot machines. So it seems like an unnecessarily restrictive and improperly restrictive interpretation to say that it has to be replicating a Pennsylvania-approved slot machine. Because otherwise, you're offering New Jersey, Nevada, West Virginia, New York slot machines in Pennsylvania without approval from the Gaming Control Board and without any rulemaking from the lottery, and offering them to 18-year-olds and doing it without paying any taxes, completely circumventing the entire premise behind the development of the gaming laws.
Okay, Mr. Scheinfeld. Oh, go ahead, Justice.
I just want to say, isn't the answer to maybe Justice Brobson's question is that first and foremost, and you can correct me when you have your time to speak, first and foremost, the General Assembly wanted both of these industries to thrive, but not in competition with each other.
Absolutely.
Okay.
And you know, the idea is that they are both forms of wagering, but they run parallel, right? So ordinarily you think, and I think one of the misconceptions about the statute, and I think it plays to a couple of the questions that I've gotten this morning, is this is not a Venn diagram. We have two distinct spheres. The legislature did not intend, by opening the digital space, to cause these two spheres to overlap. It clearly intended that they would remain separate, but they would also use that digital space. That's what's crystal clear from the legislative text, because you have a different definition of the games. Internet instant games, what the lottery is permitted to offer. Interactive games, what the casinos are intended to offer. And the legislature reiterated that distinction twice in two separate provisions. First, by defining iLottery games as specifically excluding interactive games, and second, by defining iLottery games as not including games that simulate casino-style games. The intention of the legislature couldn't be more clear, yet the Commonwealth Court obliterated that.
It actually could be. It could be. It actually could be a lot more.
The intention couldn't be more clear. The methodology for implementing it could be more clear. But remember that the legislature also directed the Department of Revenue to promulgate regulations. And to this day, it has not promulgated a single regulation. It has not even proposed a single regulation to define what casino style means, to define what is the scope of permitted use of the games. It hasn't put anything before the Independent Regulatory Review Commission. It hasn't put anything out for public comment that could accurately reflect this intention of the legislature, despite the clear legislative direction that it engaged in rulemaking.
Okay, Mr. Steinville, do you want to wrap up?
The court, I think we've covered everything that I hoped to cover in statutory construction. The court also asked for argument on the exclusion of the expert.
Those will be moot. Those other two issues, the one that we took on submission,
Yes.
and then the Lightman issue, those would both be moot if you win on your first issue, right?
I believe so, Your Honor.
And we have the briefs on those.
Yes. So if the court does not wish to hear argument on the expert issues, I'm happy to take my seat.
I
Thank
think,
you.
I think there's a good chance we understand your argument.
Madam Chief Justice, and may it please the court, my name is Michael Scarinci. I'm a Deputy Attorney General with the Pennsylvania Office of Attorney General. I'm here representing Appellee, the Commonwealth of Pennsylvania, the Department of Revenue. Judge Cohen Jubileer, after hearing 5 days of testimony and reviewing hundreds of exhibits, wrote a meticulous and comprehensive 46-page opinion that included over 100 paragraphs of factual findings. Contrary to the casino's assertion, Judge Cohen Jubileer did not make any error of law in her statutory analysis. That's why the casinos have to resort to misdirection and straw man arguments about conclusions that Judge Cohen Jubileer never made. I think I'd like to just get right to the heart of the matter here. I know a lot of questions have been on the definition of a slot machine found in Chapter 11 of Title IV. And I have to first point out to the court that this is not an issue that was raised below. No one asked Judge Cohen Jubileer to apply that statutory definition. I think likely that's because it was not terribly helpful to my friend here. That definition does use the definition does use spinning reels, so likely not helpful to them. I also have to point out that that particular provision is found in Chapter 11 of Title IV, which deals with gaming. The prohibition against simulating simulating casino-style games is in Chapter 5, so it's not the same statute. Moreover, I think what's important...
I believe they're in pari materia.
I don't, and I'll tell you why. That definition has its origins in the 2004 Pennsylvania Racehorse Development and Gaming Act. And as you pointed out, in that 2004 legislation, by the way, the prohibition came 13 years later. That definition, as part of that legislation in 2004, the legislature created the Pennsylvania Gaming Control Board. So, and as part of creating that board, The legislature wanted to give the board broad authority, so broad that they have sole regulatory authority of every aspect of authorization, operation, and play of slot machines. They also used a very broad definition of slot machines, which I think is different than what Judge Cohen-Jubileer was asked to answer here, which is, what is the essence of a slot machine? And after hearing all this testimony, she concluded that the essence of a slot machine is pay lines and spinning reels. Their own expert testified that the visual indicators of a slot machine are pay lines and spinning reels.
How do you explain the fact that just across the bridge, New Jersey, which has a lot of experience with gaming, sees it the other way and disagrees with Judge Cohen-Jubileer about this? It looks and feels and has a player experience like a slot machine.
Well, the one game I think my friend referred to was the volcano eruption game, which I have here. I'm looking at right now.
Did you win?
I only have it on a sheet, Your Honor. There are two, actually, so I think there's some misunderstanding. There's two actual games of volcano eruption. There's one that's a slot in New Jersey, and there's also one that's an internet instant game. The one that's an internet instant game does not play the same as a slot. The slot has a 5x3 grid. It uses spinning reels, and it uses pay lines. Our game has 9, it's a grid, but it has 9 boxes. It's 3x3. It uses a reveal function. It looks like, kind of like the memory game. You turn one over and you see if you won. It does not require pay lines. It requires matching. I believe they don't even have to be touching each other. So it's not the same game. In fact, if you go to the website, I believe there was testimony at this at the trial. If you go to the website and you play the volcano eruption internet instant game, when you say exit, it'll say, do you want to play the slot version? So it's not, there's two different games. One is an internet instant game, one is a slot. Yes.
Bear with,
I know the judge indicated her definition of slot machine was pay lines and spinning reels, but under its definition, 1103, there's also the conductor before video displays, which I believe counsel was arguing. So why don't you share with
Sure.
us why we should not find that the trial judge did not include the entire definition, just a particular section of 1103 1B.
I believe, and I think it's a paragraph 40 of her finding of facts. Visual image is visual image of a spinning reel. So it's spinning reels or a visual image of a spinning reel.
That's the court's interpretation.
I believe there was testimony at the trial that it's a visual representation of a spinning reel.
Counsel, can I?
Sure.
Justice Weck talked about going to New Jersey. Maybe we have to go to New Jersey for this, but we could also cross the river over here. Are you saying that the only machines, devices, that the Gaming Control Board approves as slot machines in Pennsylvania casinos all have one thing in common? That would be either a video or actual spinning reels and pay lines.
I believe that there's a small minority, that's the testimony at trial, there's a small minority that either lacks pay lines or spinning reels. An example of that I could point to is the game called Gonzo's Quest that they put at trial. That is a game that has pay lines. It doesn't use spinning reels. It uses a function called cascading reels. So it looks like the blocks are falling down, kind of like
Tetris.
Tetris, exactly. So,
Which is not spinning wheels.
correct. So, or like I used Candy Crush was another game that's probably more.
So Pennsylvania's Gaming Control Board has approved as slot machines devices that do not have spinning wheels.
Yes, correct. There's a small minority. I believe the testimony is the vast majority.
It would only
yes.
have to be one, but the
Right.
Gaming Control Board does not view spinning wheels as a requirement for a slot machine.
I believe so, yes. But that does not detract from the fact that that spinning reels and pay lines are considered iconic or signature features.
Can I ask you on that feature point?
Yes.
Because you focus, as did the lower court, on what you judge to be casino-style features. But it seemed like the General Assembly was prohibiting the lottery, from offering casino-style games. the legislators didn't say casino-style features. So I wonder whether the lower court wandered into erroneous territory by scanning down feature by feature rather than looking at this in its totality to see whether it's simulating the playing experience of a slot machine. Because if in fact what you folks have, what the lottery's done is simulate the playing experience of a slot machine, then it seems the lottery has run afoul of the statute. And this quest to go feature by feature and ask, is it particular to a slot machine, perhaps loses the forest for the trees.
Understood.
And leaving us in a weird space where basically there's nothing that won't escape the statute. Can you respond?
Yes. This argument's not preserved for appellate review, Your Honor. Their whole theory at trial was that the use of a single feature rendered a internet instant game a simulation of a slot. They did not ask the trial court to consider them in totality. It was only in their post-trial motion that they asked for the court to consider in totality. So it's no wonder that the court...
Yeah, but counsel, aren't we being asked to interpret the statute, and isn't our review plenary in that regard?
Yes, Your Honor. And my answer on the merits is that Judge Cohen-Jubilee looked at all the features and said, as I said in my brief, 0 plus 0 is still equals 0. All these features are characteristics that have been found historically in traditional lottery products or more broadly in any games of chance. Some of these features are required to be used by statute in our games. Things like a reveal, that's required in the statute. Thing like a random number generator, that's also required to be used in the statute. Things that they challenge that are just products of any games of chance, like the return to player percentage. That's...
See, and in keeping with Justice Weck's question, or I think his thought process on this, you can see the use of the phrase casino style to be a signal to the lottery to stay in your lane and stay out of the lane of what casinos do. And why isn't that a perfectly reasonable interpretation? It goes back to my question to opposing counsel. What would be an acceptable internet game for the lottery to pursue? I mean, I was thinking he was going to say, well, they could do what they do, but do it online. And no problem with bells and whistles and things of that nature, but what the lottery was selling at the time that this statute went into play was essentially the lane that the legislature wanted the lottery to stay in when they used the phrase casino style. Why isn't that a reasonable reading of this statute?
Well, we did stay in our lane by not using features that are particular to or characteristic of slot machine.
Well, see, getting back to Justice Weck's point, I mean, that's a very limited analysis of what that phrase means. Breaking it down into features sort of takes away from the breadth of the phrase that the legislature used, which is casino style.
Well, the court used the typical definition of style in her analysis, which means a particular kind, sort of, type, as with reference to form, appearance, or character. So if we're talking about appearance, as I know some of Your Honor is focused on, what a slot machine appears when it displays its function, it's pay lines and spinning reels. It's not, I don't think there's players that walk up to a game and say, I know that's a slot machine because it uses a random number generator, has an RTP of 95%, and has infinite play, non-depleting pool price. I think they look at the game, as even their experts talked about, and they say, oh, it has spinning reels, it has reels, and it uses pay lines. It's a slot machine. They wanted to use much more nebulous definitions of a slot machine, definitions that were not workable. Their own expert, Mr. Schultz, at page 1392, when asked, what is a slot machine, said, a slot machine is basically a piece of software that accepts a form of payment from a player in return for a random chance of an outcome with pays that are available to be seen on a roster, and usually those outcomes are usually displayed in the form of some sort of similar group of symbols that have or even that have defined patterns as to how they represent a winning outcome. That is not a workable definition of a slot machine. Our expert, Mr. Lightman, gave a very workable definition, which is that it looks much like 100 years ago, except there's digital representations of a pay lines and slot machines. And again, their own expert said pay lines and spinning reels are visual indicators of a slot machine.
I could share with you my thought when I saw the findings and conclusions of the trial court in this case, and I thought, geez, if that's what the legislature intended, it would have been really easy for them to say you can't use spinning reels or pay lines.
Well, they left the terms I understand that. They left the terms undefined, so Judge Cohen-Jubileer was left with interpreting those undefined terms in accordance with their ordinary meanings. And she synthesized the statute and came up with a workable definition of what is a slot machine. I don't think using the ordinary definition is any error of law.
Well, but the significance, and you talked about the depleting prize pool component.
Yeah.
Prior to, the lottery, other than the number drawing, where you could have, randomly get the same number and, oh my gosh,
Sure.
800 people have won. But the typical lottery games had a diminishing prize pool. Only they were printed at the time. It was a predetermined number of winning tickets that went out into circulation and things like that. Casinos have always been different. There's never been a defined number. Everybody had the same exact chance when they walked up to a slot machine to win the prize, and could win multiple of the same prizes. Why isn't that a big difference between lottery and casino games?
Well, because that depleting pool prize, we see that in scratchers, but there are other games that have not used that. So Keno, I mentioned, is a game that has an infinite play, non-depleting pool prize. And as Judge Cohen-Jubileer found, it was historically used in traditional lottery products, so therefore it cannot possibly be something that's particular to a slot machine. It's also a security measure. She mentioned that it's beneficial to the to the internet instant games to use that, so that there aren't people who get together when, say, the game, there's a number of top prizes left. There's something called a syndicate. People get together and they buy all the remaining games and take in more.
Doesn't that indicate?
Which makes the game anti-competitive.
Yeah, but the fact that the lottery has gone into that non-depleting territory to thwart the syndicates, isn't that suggestive that you've crossed the line into casino territory? I mean, the lottery was created to, take over the numbers rackets, right? And now isn't the lottery trying to take over part of the casino industry?
Well, no.
Where does it stop? Where does it stop in the internet space?
Well,
Using this definition that the lower court came up with.
Well, in terms of, I'm sorry, Your Honor. Well,
as long as you don't have the spinning reels,
yes.
you can do anything that looks a whole heck of a lot like a slot machine.
Well, these are features that have historically been used in traditional lottery products or many games of chance. So it's not particular to a slot.
You keep saying that, but
Yes.
you have to live and die by what the Commonwealth Court judge said here.
Yes.
If it doesn't have a pay line and if it doesn't have spinning wheels, it's fair game.
Correct.
You can't.
Yes.
Every time a justice up here has asked you that, you've kind of, well, that's just the typical historical.
Yes.
No, that's the definition that is being challenged up here on appeal.
Right.
And
I think
so,
they're two sides of the same coin, though. Your
Okay,
Honor.
so based on that definition, to Justice Weck's point, if you walk across the street and go to the Rivers Casino and you find a slot machine that's been approved by the board as a slot machine that doesn't have spinning wheels and doesn't have a pay line, you could take a picture of that and make an iLottery game out of it, and you'd be fine, even though the board regulates it.
So I just want to clear up one thing. So I'm not aware of a game that was entered into evidence at trial that lacked both a pay line and a spinning reel. There might be one game that was mentioned.
I'm talking about your concept,
Yes.
which the Commonwealth Court said that as long as you don't have a pay line and a spinning wheel.
Yes, that's correct.
And
Yeah, I
that's
agree
why-
with that.
And you admitted to me earlier that there are games that the board has approved that don't have pay lines or spinning wheels.
I could think of one, yes.
Okay,
Yeah.
so under your definition, under the Commonwealth Court's ruling, you could take a picture of that, simulate it, put it up on the iLottery website, and you would be fine, even though the board says it's a slot machine and has regulated it.
Yes, I think so, in that one rare instance. I think there was only one game entered at, not even played, but just mentioned that there's a game that doesn't have pay lines or spinning reels. Now, there are,
Yeah, I mean, following up on Justice Brobson's colloquy with you, as we interpret this statute or this statutory language, is there any compelling reason why we would assume the General Assembly would want the lottery to invade this space so much that it's created for the gaming industry?
well, we haven't invaded their space. In fact, I wanted to provide you some updated figures. They, this past 21-22 fiscal year, the casinos pulled in $3.2 billion in gross revenue. That's $2.4 billion in land-based slots and over $800 million in iSlots.
Yeah, and they bought, and they paid for it. I mean, they bought a license to do it.
Sure, at the beginning.
Taxes on
They do.
what they're doing.
Right, but they, so, but,
There's a lot of people who
Sure.
want to play these games.
sure, of course.
Whether it's wise or not, that's up to the people.
But my point, yeah.
There's a high effective tax rate that's
Of course, and I was just going to get to that. Okay, so 3.2 billion in gross revenue. That's before the approximate 50% tax. Our last year was 71 million in profits. So it's about.
Bring you back to your own comment. That's not the issue before this court.
Well, it is an issue because, as you brought up, these games are supposed to coexist, and they are coexisting. They took in 1.6 billion after taxes. We took in 71 million of profit. If that's 96% of the market share, we have 4%. I mean, let's call a spade a spade. This game for the casinos is not about interpretation of the law. It's about pushing a small player out of the market so that they can have a 100% market share, contrary to the intention of the legislature.
You weren't supposed to be in their market.
Right, we're not in. I think we're talking about a broad market in terms of people. Even their own experts talked about. Well, I consider every dollar out there a potential dollar. You know, instead of a dollar going to betting on a football game, they could be betting on a slot machine. So it's a very broad market that we're talking about.
Effectively, isn't it? The case is exploring how those two different markets emerge into the internet space, right? So we have to help define what the legislature intended in that space, and it looking at these games online, it looks like well, let me just stop there in case you want to comment on what I said so far.
No, go ahead.
Okay, I'm done. I'm musing.
So I'm assuming that wasn't a question, Your Honor.
Sorry.
Mr. Scarinci, I
Yeah.
think we're going round and
Yes, I don't have much to add here. So I know you didn't touch on the expert issue. I'm fine to rely on my brief for that if you'd like to stop now. So we.
Well, I was going to give you a moment to wrap it up if you'd like.
Yes, our position is, I think you understand our position, that you affirm the well-reasoned opinion of Judge Cohen-Jubilaire.
All right.
Thank you very much, Your Honors.
So, very well done.
Very nice.
Commonwealth of Pennsylvania versus Rodney Sterling McGee, representing Mr. McGee, Mr. Corey Woods, representing the Commonwealth, Ms.
Sorry.
Good morning. In this appeal by allowance, we must determine whether a trial court's inherent authority to correct patent and obvious errors in its sentencing orders is constricted by the jurisdictional time bar of the Post-Conviction Relief Act.
Good morning, and thank you, Chief Justice Chad, justices of the court. Corey Woods here today for Mr. McGee, and to some extent for the power of just about every trial judge in the Commonwealth of Pennsylvania. This case is sort of a referendum on the Superior Court's case in Jackson, which held that the inherent power of a trial court to correct mistakes in its records and make its records conform to what actually happened in the case time bar. The decision is based on, number one, a misapprehension of the claims and sources of jurisdiction at issue, and two, a misinterpretation of the PCRA time bar, not as a restriction on the PCRA's grant of jurisdiction, but as an independent sort of grim reaper of jurisdiction of all kinds. There are two kinds of claims at issue, two sources of jurisdiction. The first one is that inherent authority to correct mistakes. That, under this court's precedent, is proven by either contradiction with the record or contradiction with black letter law. Why? Because, again, the trial court should be allowed to make sure that its records reflect what happened. It should be like neither an iLottery game, nor should it simulate a casino. It should be consistent with what actually happened. That's one claim. That's one source of jurisdiction. The other claim is under Section 9543 of the PCRA, which is for illegal sentences. So these are two different types of claims. One says this order, whether it's a sentence or any other order, is a mistake, and that's proven in various ways. And the other kind of claim is that this sentence is illegal, please modify it.
There's overlap, right?
Well, there is going to be overlap as to which orders, the same doctrine can, different doctrines can apply to the same order, but the claims are different. And that's kind of the question at the heart of this case. So if we look at the claim that an order was a mistake, and the way I've always said is that oops is different than wrong, right? If you look at the first kind of claim, that an order was a mistake, you cannot go into PCRA court and say, Your Honor, under Section 9543 A1 subnumeral whatever, this was a mistake. You can go in and say this sentence is illegal. So those claims of a mistake are simply not cognizable under Section 9543.
Unless the mistake made the order illegal.
Well, in that case, Justice Brobson, I think the order is assailable as illegal. That's correct. But it is also assailable as a mistake.
Right, I understand that, but the point is, your client wins either way. They could challenge it PCRA, and considering it's a patent defect, obviously people should know right away from the face of it that it's an error, so there shouldn't be an issue with bringing a timely PCRA. But the fact of the matter is, if we adopt what you're saying, your client there's really no reason to bring a PCRA timely because they can always seek this correction at any point in time.
Correct.
Okay.
However, one thing I want to emphasize is this authority to correct patent mistakes is extremely limited. So I take the Justice's question as suggesting, we don't necessarily want to interpret the PCRA in a way that leads to just a proliferation of litigation about mistakes, but this Court's decisions in Klein, Holmes, Boren, et cetera, have really limited that. And
I'm sorry, counsel, share with us, it's obvious that patent mistakes, it took 24 years to find this mistake. How is this patent not a latent mistake such that it's not deserving of review?
Yep. So the first thing I would say, Your Honor, is that in the briefing for this court, and right now is the first time I'm answering this question, I think it's waived by the Commonwealth. I don't think it necessarily is something we need to reach. However, this was a plea, so there was a plea entered that day. I don't believe there was a direct appeal taken, so we didn't have counsel looking at the record on that day. We had one PCRA that ended in a very, very small no merit letter, and then I was appointed far, far after the point. So I think, just practically, no one really looked into this. And I'll be candid with the court. I was a...
Does that not
Well, I think no one looked at the records, Your Honor, until I got, and I'll be candid, I looked for any potential PCRA claims I could find, and there just weren't any. And
You're the one who found the mistake after all those years, and to your credit, and it's important in this case, it seems to me, that the judge was an entirely different judge. The judge who had made the error was off the bench, gone, right? So going to your point about the narrowness of this area, can you offer us the best characterization of what the parameters of that narrow area would be were we to rule in your favor here?
yeah, so I think the court's identified it. Is the mistake apparent from the record itself, on the face of the record? Commonwealth has suggested it's got to be on the face of the particular order, but that's not true. When you look at Holmes, for example, you can't sentence a parolee as a probationer. Time credit can be amended itself.
Well, here it would be obvious from looking at the two orders.
Right. And one of the points I've been making all the way up and down the proverbial chain here is, Mr. McGee has to know which one of these orders applies. The Department of Corrections has to, they make calculations for parole based on which one of these orders applies, things of this nature. And if we just say, oh, there's no way to resolve this, then he's got two sentencing orders that can't possibly both.
Can you explain to me why, following March 27th of 1996, within the next 2 to 3 years, somebody couldn't have physically looked in the file and seen the written sentencing order and the typed sentencing order? What makes this patent?
So I think those are two questions, Justice Mundy. I think the first question is, why didn't someone see this sooner?
Was it physically able for somebody to look in that file and see that there was two different orders, a written sentencing order that said one thing and a typed sentencing order that said another? I'm trying to figure out whether this was an error somebody could have looked and seen at the time it was created.
It was, but I'll note that Mr. McGee had just entered a plea. He had no reason to sort of go review his entire file. He didn't have a direct appeal attorney, so that person didn't exist.
Pro se, correct?
I'm sorry?
He proceeded pro se.
I don't believe that he had a direct appeal. I could be mistaken, but I don't.
No. He had counsel at the guilty plea, correct?
That's correct. So that counsel is done at the guilty plea. There's no direct appeal counsel. First PCRA counsel, and this isn't in the briefing, but just anecdotally, I can say I think the two orders were not docketed in the computer system, so I had to actually go into the court file and review all the documents, and there was just this handwritten order.
I think my point is we're looking at for ways for you to argue around the PCRA time bar, and I understand that, but I just think, in fairness to everybody, I mean, we have a set of rules and everybody should be treated fairly. What precluded your client from any time after this plea was entered in 1996, before the PCR time bar expired, from pulling the file and looking and seeing that there was a physical written sentencing order and a typed sentencing order?
Just fine. The point is well taken, and I think in an appropriate case, a district attorney might reasonably say, "Oh, latches applies here," or "There's some sort of prejudice
answer my
to
question.
us." Well, I think he could have. Absolutely, he could have. But I think in an appropriate case, it would be appropriate for the DA to say, "Too much time has passed. Latches applied," or frankly, I think it was one of the Commonwealth's amici argued that there is some sort of limitation on this inherent power. That would be a perfectly fine argument to make, and we could have had litigation over when and why anyone saw anything. We could have called in prior counsel who wrote the no merit letter, but that didn't happen. We went to a 25-minute hearing before Judge Gilman, and the DA said, and it's no offense to my colleague here, she wasn't trial counsel, the DA said, "Oh, it's a time-barred PCRA," and that's the long and short of it. So that's kind of why we ended up with this kind of teed-up issue.
And in your defense, Mr. Woods, you would have been a toddler at the time this happened.
Well, I think I would have been 8 years old. However,
Counsel, I'm still concerned, the legislation was never intended for any additional equitable exceptions other than that which is provided.
Absolutely.
So, other than your patent error, is that your ball wax?
So I am not asking for an exception to the PCRA's time bar. Obviously, this court's decisions say we don't do that. I have thoughts about that. I'm not suggesting anything, but there's a great concurring opinion in there. But the power to correct mistakes, which is the only issue here, is independent of your jurisdiction granted under 9545A1.
Well, and that's your argument, but Justice Wecht asked a brilliant question, which was, what is your limiting principle?
Yeah.
And you got out, it has to be patent, which I think we all understand that. What is your limiting principle?
Yeah. So I think Boren gives us a great example of what the limiting principle is.
I want to know, don't give me a case.
Yeah. Okay.
Because I just want to know what you're arguing the limiting principle is.
Is it apparent from the face of the
That's
record?
patent. Other than patent, what's the limiting principle?
Is it contrary to black letter law?
That's an illegal sentence.
No. So, for example, it could be true that a sentence exceeds the statutory maximum.
Right.
Okay. I don't know that this court's decisions about what black letter law is would try to figure out, well, is this crime a misdemeanor 1? What's the maximum sentence for that? I think that's a question of, is it contrary to law? Black letter law is something like what was going on in Holmes, where a parolee is being sentenced as a probationer to additional time, or something like here where merger is involved and it's just, it's clear that it's a mistake.
So again, testing your point, if a trial court judge issues an order that on its face imposes an obviously erroneous max sentence, it's like, everybody coming out of, life for a misdemeanor. Let's say life for a misdemeanor. That is an obviously illegal sentence. You would agree?
I would agree.
Would it fall within your view of this judicial authority outside of the PCRA to correct?
So I think life for a misdemeanor might. I don't know.
Right.
But I think...
Well, I need you to know, because your entire argument is based on this, that there's this limiting principle that differentiates between an illegal sentence that is a clerical error versus an illegal sentence that is not a clerical error, one of which is only challengeable under the PCRA and the other of which is challengeable both on the PCRA and through this motion. Holmes didn't involve a motion, by the way. Holmes was the court act. I understand what the difference is between those two.
Yeah, so I think what black letter law is still an open question, but I think that, let's say we have someone who's sentenced under the misimpression that a felony 3 was actually a felony 2, or a misimpression that the maximum sentence was 10 years when it was 5 years. I don't think I would be here saying this is black letter law. Blackstone would say this. It's just a basic principle. And here's the goal of what I think black letter law means. Is the law clear enough on this point that we can look at the order and say, oh, the trial judge just made a mistake, versus this is the sentence he intended to impose. I think if we're talking about life for a misdemeanor, there's got to be a clerical error in there.
And to follow up on that, you can apply that standard, I take it, to this case and get relief without needing to extend that standard to factual scenarios which might be closer to the line, given the coexistence of two incompatible orders here.
That's correct. So we don't even necessarily need black letter law. We have something that's closer to, I believe it was Klein, which, Cole, where we have irreconcilable orders that say we're going to grant you a judgment of acquittal and a new trial. So, the argument before the trial judge in the motion to correct the record was this is obviously irreconcilable, and it's contrary to black letter merger law.
Let's assume that you didn't have the two contradictory orders, two different pieces of paper, and what you had was just the typewritten order. The Commonwealth, I think, belatedly argued it's not a mistake because there were two victims. I mean, so what makes your case with the written order a case in which the dynamic of obvious mistake or error apply?
Yeah, so just to be clear, I know the Commonwealth argued that.
I said belatedly.
Yes, they did argue
did
belatedly,
say
but they
that.
also were just factually wrong. If you look at the information, the counts at which he pled guilty were the same victim.
Okay, and your argument would be based upon this record, not just this order, but on the record, you could determine that this is violates black letter law.
That's correct.
Even
And
if-
it is a belt and suspenders sort of situation. But the other thing I wanted to say is, I don't think we necessarily have to get into the questions of, is this black letter law? Is this actually a patent mistake here? Because those questions were not raised in front of Judge Gilman. The Commonwealth just came in and said, well, this is a PCRA petition, and it's time barred because it's a PCRA petition. And
But my concern, and I'm not presumptuous to believe that my colleagues share my concern, but my concern is this was a motion. It wasn't Holmes, where where the judge just looked at an order and said, "Holy cow, I made a mistake," and sua sponte corrected it. Unless we, in this case, create some limiting principles, my concern is in fact, it's virtually certain that defense counsel doing their possible best for their clients will start filing these motions, and we will be litigating ad nauseum in the trial courts as to what is a patently illegal sentence that is available to challenge under the PCRA and under this principle that you are pushing here. That's my concern, is we're opening the doors.
And that's fair enough, Justice Robson, but I think the doors are already open if counsel's willing to do this, because we already have the case law that says, well, if it's contrary to black letter law, and there are some of these cases that do involve motions. I know Holmes wasn't, I believe Klein was. And one thing I'll say is this. We're talking about mistakes the trial court makes. The trial court's a pretty good valve as to whether or not they made a mistake in most cases. We already have a lot of litigation in the trial courts about time credit under Klein, and the courts have not buckled under this because it's just a really narrow universe of claims where you can say, oh, look at this. This is a clear oops. And
Well, I've seen them in Commonwealth Court where there was an issue about whether someone is up for parole, whether they've reached their minimum or maximum, and in the process of having counsel, they figure out, oh, the judge said concurrently, and he meant consecutively, he meant concurrently, and our answer has always been, you need to go back to the trial court and have them correct the order.
And that's actually an interesting point, Justice Robson, because right now there's a weird jurisprudential confusion where the trial courts are sending them to the Commonwealth Court, and the Commonwealth Court's sending them back.
I'm sorry.
But I think, there are very, very few cases where, a reviewing attorney is going to say, oh, holy smokes, look at this record. It's just a clear mistake. And the trial court's a valve on that, and we do have those cases that say black letter law. Is there going to be some Superior Court case law on what black letter law is? Sure. But that's a normal way for the law to develop, and I think that would be true even if we didn't.
Let's follow that argument. Up there, what is it, 95.3A2, the imposition of sentence greater than the local maximum. The black letter law says that's what your case is. So therefore, why are we looking at it under a case mistake when it's strictly a PCRA issue, and then our determination doesn't meet the time requirement of 1 year, and the answer is no. Case over.
So I don't know that a maximum sentence is or is always black letter law. And I think if you look at Holmes, we're talking about legal principles that, your first year law student should know.
Position of a sentence greater than the local maximum. We know that the attempt and the assault, attempted murder act assault should have merged. So technically, if although it doesn't have an effect on your client's liberty. But yet, so therefore, based upon your argument, I guess what I'm saying is, I think you argued yourself to a loss right now, because I'm viewing your argument, particularly you're stressing the black letter of the law, clearly indicating that the factual scenario here falls within the PCRA, and such that you are restricted by the time limit. I don't know how you're getting around the other 55, what is 5505?
Yeah. So I think I understand your question, and I think the ambiguity here is what black letter law means, and I think the jurisprudence in this line of cases would view that a lot more narrowly. I think under those cases, black letter law means something that is so obvious that you can confidently say, oh, this is a mistake. This is not a sentence that was intended to be imposed. This is a mistake. I think if you have a sentence that is higher than the legal maximum for a misdemeanor of the second degree, that's cognizable under the PCRA. But I don't think that's contradictory to black letter law. I think it's contradictory to law, but I think black letter means something a little higher.
You're almost stepping on double jeopardy. You're saying he got sentenced for attempted murder, he gets sentenced for ag assault. Fortunately, it was concurrent when it should never have been sentenced, because it should have merged.
Right.
Therefore, it meets the black letter of the law of the PCRA.
So I just don't think that the case's contemplation of black letter law is the same as the sentence higher than the lawful maximum. I think the cases contemplate a much narrower set of claims. So
Isn't your answer to Justice Doherty's question the answer you gave me earlier, which is yes, he could have brought it under the PCRA,
Yes.
but because it is a challenge to the illegality of the sentence, but he also gets to bring this motion for equity from the court to correct a record under jurisdiction, which means that because he didn't bring it within the 1 year of the PCRA, he hasn't waived it. He will have it in perpetuity.
So no, because there's two different claims here. He could go to court and say, this is an illegal sentence under Section 9543, etc. This is an illegal sentence. You can do that for any kind of legal sentence. You can raise, all sorts of claims under the PCRA. You can do that. That order is invalid on that basis. What he is saying is, regardless of whether it's contrary to law, it's a mistake. Now that is
And a very obvious one.
in a very obvious mistake, and here's the problem. Here's where everyone is making the conflation. One of the ways that you can prove a mistake is that it's contrary to black letter law, or it's contradictory under the record. But that doesn't convert the claim that it's a mistake or a clerical error into a claim it should be reversed because it's illegal.
Or it's in this instance, self-contradictory.
Correct.
And in this case, just to follow up, this case happens to be one that's in that small area of overlap. But one can readily imagine cases that are patent and obvious mistakes, that are not in the overlap area, that are either in the area of illegality but not patent and obvious mistakes, or conversely, that are patent and obvious, like Potter Stewart. I know it when I see it, right?
Right. I am not coming to the court and saying every illegal sentence in the world is subject to one round of review under the PCRA and one round of review to correct the record. That I think we have problems with. But the way that the jurisprudence has resolved that is, out of all the universe of illegal sentences that are imposed, there is some smaller subset that it's clear because either, and it's not just because they're illegal, but some of them are clearly contradictory to this set of legal principles that are so obvious that you can say, oh, this had to be a clerical error, or they just made a mistake. You can also show a mistake by saying these are irreconcilable orders, for example, or as the court contemplated doing in Boren, here's a good example. Let's say the trial judge says, I'm going to sentence you to 5 to 10 years. That's a legal sentence, but the sentencing order says 6 to 12 years. And that's also a legal sentence. We can already go in and you intended this lower sentence. It's in the transcript. It's clear and unambiguous, but the sentencing order just didn't connect. That's not an illegal sentence.
Legality of the sentence is a much safer space
Yes.
for us to all wrap our heads around. It's when you get into the illegality cabin that I'm concerned about.
And I think the answer is, under these cases, black letter law is just so obvious that you say, oh, well, it's what Judge Gilman said here. Oh, they should have merged, he just missed it. And that's a, law by law analysis of what's so clear. But I think that's something that, jurisprudence will develop to clarify.
Are there any other questions for Mr. Woods?
I just want to clarify, you have not pursued an argument that the legislature cannot interfere with the court's inherent power to correct a mistake.
I have not. I know our amicus did
But you have not.
make
That is-
allusions to that.
That is not before us.
I don't think so. I think that if the court is inclined to engage in statutory construction of the PCRA statute, the constitutional avoidance canon could come into play. But I think the simplest one, that you're wrong.
But just as Donahue's point is interesting, because one, we've asked about this case in a number of different directions, including presumably, arguably, aren't we divesting the successor judge of a mistake that's completely obvious to him or her? In this case, him.
Yes, and I think frankly, amicus makes some fair points, right? If anything is inherent to what a court is, it's to make sure that what it intended to do is. But again, I think it's a great concurrence.
Apparently, given the given the questions that you've gotten, but I mean, and it's not only limiting Judge Gladden's authority. It's if Judge Gladden had been shown this mistake, the two issues of those two could be seen as conflicting.
I
sources of
don't
authority.
think they actually intersect. I don't think and the basis for relief is look at this and say, oh, this is a clash of the titans, right? This intersection of the inherent authority and the PCRA time bar. But I just think that they're running on separate tracks.
You do. I know that.
I do.
All right, thank you. Thank you, Mr. Woods. Let's hear from Commonwealth, Ms. Gersner.
May it please the court, Cassidy Miller Gersner on behalf of the Commonwealth of Pennsylvania, Madam Chief Justice and fellow justices. I think it's important to remember the PCRA strikes a reasonable balance between society's need for finality in criminal cases. Power to address an obvious sentencing illegality is subject to the jurisdictional PCRA time limit. The time limits demonstrate the intention of the legislature for that finality. And I believe the factual scenario presented to your honors demonstrates that this is an illegal sentence and it is contemplated under the PCRA. Section 9542 of the PCRA, as well as case precedent, specifically Commonwealth versus Prinkley, or as well as case precedent, specifically Commonwealth versus Prinky.
Were also illegal. I mean, in other words, haven't we already decided this?
Truly patent, which I would argue that it's not in this matter before your honors, that it would be resolved at that point. I think there is a danger, and that's why Jackson and Holmes don't necessarily coincide, because in Holmes, the issue was corrected, not within the 30 days, and I believe Whitfield, but within this 1 year that it could have been taken up under the PCRA. In Jackson, and in the case before you, this is 25 years later, evidence is lost. I believe the justice homicide and the aggravated assault merge, and that's why it wasn't caught. I think Mr. McGee knew what he pled to. It was negotiated. I think whether merger is patent. It is not. I don't think it's something that's obvious on its face. And I'm sorry, what was the second part? If you granted relief?
Holmes, would this take us beyond? I think that's a fine answer that
What's really interesting about Holmes is that the decision was very narrow. I think that if I honestly didn't catch it at first, is that the defense and the Commonwealth argue PCRA jurisdictional time bar, but the holding is extremely narrow, that it doesn't address the PCRA time bar. It only addresses the inherent authority of 5505. Justice Eakin, I believe.
Only
Okay.
that I kind of wish you hadn't appealed.
Me too. But that's all. There's been a lot of talk about it. Clearly, it wasn't me.
Very, very well done by both sides.
Thank you.
I knew it.
Mr. Woods, you were court appointed in this case, is that correct?
That is correct.
Okay, well, nice job. Very nice.
Donald R. Bindas versus PennDOT.
So what you're saying is both the trial court and the Commonwealth court got it wrong, that your client actually had actual notice because of the chain of title in this case. I just have to look at it more closely because they were both very clear on that point.
That's correct. That's our position, Your Honor. And Judge Seisler in the Commonwealth Court noted the lack of actual notice as well. But so when you look at the joinders from our deed, and even the Tax Claim Bureau looked at it as one lot. And when you went back through to Mr. Kohler, there was no mention of this plan. So turning back to the statutory language, the recording, the statute basically gives us a picture, it gives us the instruction on what recording is to look like. The Commonwealth Court didn't find that this indexing was necessary or a plan book was necessary, just that Washington County received it and said it was recorded. But this mandatory language in Section 210 makes it clear that the recording needs to be in a plan book or books, and it needs to be indexed with a locality index. It spells it out all in one section here. And the Commonwealth Court's reading of this essentially makes that language in relation to the plan books and in relation to the index, superfluous, as unnecessary, which would be contrary, once again, to Section 1921 of the Statutory Construction Act. We should read that statute in its entirety, giving effect to all of its provisions. And they failed to give effect to the provisions with regard to the statute's requirements of requiring a plan book and indexing.
Can I just clarify one other point then?
Certainly.
Are the opinions and the record correct that when PennDOT or the Department of Highways recorded the plan was assigned a deed book and volume number?
That is correct, Your Honor. That is correct. Which leads me to the second point with regard to the second issue, and whose responsibility or burden it should be with regard to seeing that the record is correct in the local county. Obviously, Section 210 does not speak to this. In my arguments before the trial and the Commonwealth Court, I relied on the precedent in Prouty versus Marshall. There, it was noted by Justice Potter, who wrote that opinion, that the great object to be attained by recording and indexing an instrument affecting the title to real estate is to give notice of the encumbrance. And to that end, I cite in my brief an earlier case from a predecessor statute to the statute in question. It is the Urbanski case, which it notes that under that earlier section, the only thing that was required was approval by the governor and filing in Harrisburg. And Urbanski, in that decision, said the filing in Harrisburg is notice of the appropriation. It's necessary for the condemnation, without which condemnation doesn't occur. So I analogize from that case when this statute is enacted approximately a decade later in the 1940s, and then they add the fact that not only, recording in Harrisburg is required, but now it needs to be in the Recorder of Deeds office locally. So not, every person who has a piece of property abutting a land or abutting a highway has to travel to Harrisburg to see whether that parcel is affected by an easement that expands beyond where it's improved. They can look at it in their local recorder's office. And as such, it is an important and necessary part to the recording.
Counsel, can I ask you to clarify something? You sort of jumped from Prouty to, in Prouty, there was a defectively recorded mortgage. It was recorded in the wrong place. That's not what happened here. The Department of Highways took the plan to record it precisely where it was supposed to take it to record it. So what's your theory that you're getting to the point that somebody bears the burden of the error of the county's recorder of deeds?
Correct.
Why would that be PennDOT?
So in Prouty, just to clarify, yes, it was a mortgage, but it was not only defectively recorded, it was defectively indexed as well.
But it was defectively recorded. One without the other doesn't get you Prouty.
So in our case, it was recorded.
Correct.
And my point in invoking Prouty is this, that the lack of recording in the plan book as required by the statute, plus the lack of indexing, is the burden of PennDOT because it is the one who holds the instrument. It is their claim. It shouldn't be put on an innocent purchaser down the road like Mr. Bindas in 1977.
How about the original purchaser? Why isn't it the original purchaser's burden to make sure that it's properly recorded? I mean, they didn't record the quitclaim deeds either.
They didn't, but that was...
So, I mean, I'm just trying to get to the essence of the theory that the Department of Highways bears the burden of this error when the original property owner was paid fair value for the property. Why is this PennDOT's problem?
Because consistent with...
Because it has to be somebody's?
No, because, Prouty sets forth what has been consistent in practice for decades, which is the holder of the instrument is the one making claim to the land, and it's their interest that needs to be protected. The purchaser, like Mr. Bindas down the road, he doesn't know about what happened in the 1950s. As for Mr. Kohler...
The Department of Highways did precisely what it was supposed to do. They took the document to the correct office and recorded it. I mean, I understand your point that this is somebody's problem, but I'm just I'm struggling with the rationale for having PennDOT compensate once again for property that the Commonwealth compensated the property owner for when the condemnation took place.
So...
And you're just saying it has to be that way.
Well, let me explain. In that transaction, they recorded. They got back a face sheet to their plan. It told them a book number that it was supposedly in and a page number. So other than the recorder of deeds, PennDOT's the only one who knows that book and page number where their claim is recorded and lies. They can cross-check that very easily like everyone else does.
Why?
But they don't have a burden to do that. There's never been a requirement that they do that. I don't know that there's even an expectation that they would do that.
Or anyone who files a document. I mean, there's some notion that, you rely on the effectiveness of the government agency with which you're filing your document. And I mean, that's what I'm struggling with here. I mean, I understand your position. I understand your client's position. I have to take a little closer look at that chain of title issue. But assuming that that's correct, I'm still struggling with why the Commonwealth of Pennsylvania through PennDOT has to go through another fair value assessment and pay again for property that was paid for, and the appropriate documents were recorded and filed as the Department of Highways was expected to do at the time that it was done.
Well, following with Prouty, the burden remains with the holder of the instrument. That's where I'm coming from in the origin of my argument. And in practice, not only I, but all the practitioners that I know of, we double check when we file a deed or mortgage after the fact. And we're the ones who have, what's that?
You do not.
I do.
You said you do not.
No, we do. We do check.
That would be-
No, let me clarify. No, we do check when the deed and or mortgage is recorded. It comes back to us. We go back to the recorder's office to ensure it's in the book and the number and in the indices as it should be. And I cited several cases in my brief with regard to one being the Orris case, which dealt with whether or not a recorder should be liable for the mistakes of its employees in misrecording something. And then there's several other cases in there that dealt with, fell on the person who was making the claim of the lien. They need to go back and check that index. They're the ones making the claim.
Do you need this argument in order to prevail? I mean, I'm not certain where I stand on the alternative argument, but I thought what you were asserting was there was no condemnation. Justice Donahue, you're wrong. It doesn't matter that they paid the owner of that property fair value for taking that property. The statute says these are the steps that has to be followed. They weren't followed, therefore there was no condemnation.
I would agree with you that if you found in my favor on the first instance, in the first issue,
And that's your principal argument.
that's the principal argument, correct. That there is no taking pursuant to Section Highway 10 that's effective, and we start at square one, and you know that's a failure that comes from that's dictated by the statute that should have been done.
Mr. Eggers, there's no other remedy that you could conjure up, is there?
In terms of the loss from Mr. Bindas's
Yeah.
use of his property, I mean, not that I'm aware of. You know, it is something, he's held this property for as long as I've lived, so 46 years, okay? And obviously Mr. Mertens and I have been going through this litigation for 6 years now, or thereabouts. And no, he raised a timely objection to it, and their position was there was no de facto taking because we own it already, and full stop, and that's where the trial court stopped. Obviously our position is contrary to that because we're saying the statute wasn't complied with here.
There's no question that there was no indexing and that it was randomly filed. Right.
Correct, and I think that's shown in the photographs that I've included, and the admission that there was no indexing by that came from the Commonwealth. So, in regard to my argument with regard to Prouty, the person here who's, you know, obviously Bindas is being affected by this claim, but the Commonwealth is saying that it's made this claim, it's effective, and once we drop it off, we have no responsibility in making sure that it's been effectively recorded. You know, the recording here and the indexing lets anyone in the future know of their claim, and it's something that, as I cited in Ladner, in other resources in property law, that burden should not be shifted to an innocent purchaser down the line, nor should it be shifted to the recorder of deeds. It's not their instrument. They have a legal duty to receive the instrument and accept it if it's an acceptable instrument and record it. But if they get it screwed up, it's not their property that's being affected. It is Commonwealth's claim to property. So in that regard, the burden should be on the Commonwealth to ensure that its filing is correctly recorded, pursuant to statute, so that, you know, the public needs to be able to rely on the fact that the statute says it's going to be in a plan book, and I can use a locality index to sift through it. And they need to ensure that their plan was in a plan book and accordingly accessible to the public and being able to be indexed so that it could be used, seen, and known throughout the Commonwealth.
Okay, I think we get your argument. Any other questions?
I just have one other question. As I recall the record in this case, your title searcher said she was aware of the fact that this was just really an issue as to, you know, how these old deeds from these condemnations, how these plans were filed, and she was aware of the filing cabinet where these things were kept and all of those kinds. Does that make a difference in this case? Because it sort of struck me as important in the context of what a title search should have uncovered when your client brought the property right next to I-70.
I don't think it does, because I think what we're looking at here in my argument with regard to the statutory construction, we're going back to whether the requirements were met with the statute in the first instance.
Well, that's your first argument, but you keep falling back on this notion that there are these consequent duties extending to the Department of Highways in 1958 and you know, up to and including the present, and that's why I mentioned your first argument is there just was no condemnation based upon the statute.
Correct. So in that regard, the fact that she couldn't find it, that it was in an unlabeled drawer, unindexed.
She didn't look the first time. She
She
knew
didn't-
about the file cabinet. She knew about the haphazard way in which these documents were quote-unquote filed 6 decades ago. I mean, that's different than couldn't find it.
But I think even if knowing what the cabinet is there, I don't know, I mean, and I don't think this is a part of the record based upon my recollection of her testimony, but I don't know that it could be established she would have been able to find what we were looking for anyways. We found it.
She did not find it, right? She did not find it, and then PennDOT provided copies.
Correct.
And then after that, at some point, she found an unindexed copy, a microfiche.
Correct. Yeah, so the way we got to it was I got enlarged copies from PennDOT. I approached her with it, and she said, well, let me look into it. And that's when she said, I think I found it in these drawers.
All right, thanks, Mr. Eggers.
Thank you.
Let's hear from Mr. Mertens.
Good morning, Chief Justice. May it please the court. My name is Nicholas Mertens, and I represent the Department of Transportation today. We ask that this honorable court affirm the decision of the Commonwealth Court and the Washington County Court of Common Pleas. Before I get into my 3 primary points, I think Justice Donahue's question really hit the nail on the head here regarding notice. Notice is a critical and absolute element in this case, and in fact in all eminent domain cases in the Commonwealth. But I think what isn't in the record is almost as important as what is in the record. And what is not in the record, and let me reiterate, I believe Justice Donahue, you also authored the PBS Coles versus PennDOT decision, that in a de facto taking situation, it is an extraordinarily high burden on the landowner claiming the de facto. What is not in the record, and I think the 2016 title search, I think that's really a red herring in this case. The question is not what was done in 2016. The question, and the record is entirely devoid of what Mr. Bindas did or did on his behalf in 1977 when Mr. Bindas purchased the subject property from the Jaworskis.
Can I ask you, counsel, I just want to inquire as to why that's the proper focus under the law. Because if Section 210 requires the counties to keep the plan books and indexes, what's its purpose if your department is not required to fill them with anything?
I will get to that point. I do believe that PennDOT, well, the Department of Highways, I
But
apologize.
isn't that in the antecedent duty? In other words, you want to go, that's why I interrupted you, because you're at 77, and if there's a prior illegality, why does the point about Mr. Bindas in 77 matter?
Well, because I think notice is a critical element, but in that sense, I may be putting the cart before the horse.
I just don't know why that notice argument mattered. Why you even get to that? I mean, the statute has to be why do you get the benefit of the failure to abide by the statutory command?
Your Honor, to that question, I believe that the Department of Highways in 1958 did fully comply with the requirement, the plain language requirements of Section 210. I would further argue that the drawer, the manner in which the plans were in Washington County did comply with the adequate locality index, and the concession that was made at the trial court was that these plans were not indexed in the context of the grantee-grantor index, and they weren't. That's a plain fact. We don't dispute that. However, the issue here, and what I believe Mr. Bindas is between the lines trying to argue, is the retroactive application of Section 404 of the 1964 Eminent Domain Code. Case law is clear that provision is not retroactive, and if I may quote from the comment from the General Assembly, under existing law, Section 210, and this is in 1964, 1963, the State Highway Department records a plan, but this recordation is of little, if any, value to title examiners and purchasers. In 1964, the General Assembly acknowledged the issue with Section 210, that there were concerns that this was not, that when these plans are recorded, that there are concerns about locating them. However, they corrected that. But Mr. Bindas is essentially arguing a retroactive application of Section 404, which is contrary to the case law.
Although one could also suggest that the interposition of that statute in 64 cast his claim into stark relief, right? Because but for that lacuna, that amendment wouldn't have been necessary, right?
I believe this honor, actually all three appellate courts in the Commonwealth, in McGowan, Payne, Strong, Engel, and Pangy, all looked at this issue prior. Now, some of those cases are pre-64, however, some are post-1964. And they all noted that what Section 210 requires is the recording of the plan, which constitutes constructive notice to all. And that's what we have here. While Mr. Bindas relies upon Prouty and its progeny regarding the recordation of mortgages and titles under Title 16 and 21, what this honorable court has to look at is Title 36, Section 210. And all the case law, I believe Payne, Strong, Engel, and Wood are all case law from this honorable court that says the recording of the highway plan in the appropriate county, and PennDOT's records in Harrisburg, which I don't believe they dispute, that is constructive notice to all.
How can that be? I guess I'm missing your point on this. Filing in Harrisburg, fine. Filing in the county office, fine. But if it's unfindable in the county office, I'm not sure how we get to constructive notice being satisfied.
Well, I think the case law does not mention the indexing. However, I would greatly dispute their assertion that this record could not be found. This is actually where I was going with Justice Donahue's, is that what the critical element, who to blame, if to the extent we must put blame, I don't think we do, but is who's the blame on? The blame goes to Bindas's actions in 1977 when he purchased the property. Was any due diligence done? We don't know. There was no testimony to that introduced by Bindas, whereas the trial court found, if I may skip ahead, found that given the location and proximity, if you think about this property, let's assume Bindas owns what he claims he owns. It's essentially a peninsula. It's nestled in between two lower trafficked state highways and, of course, part of the I-70 Eisenhower Interstate. She said that because the property is a small parcel between a major highway and a local road, a search for the highway plan would have been warranted by a prospective buyer. This prospective buyer being Bindas, a la 1977.
I don't quite follow your argument. I'm assuming that you agree that there was no notice set forth in the deed that Mr. Bindas received when he purchased the property of your taking of part of the property.
On the four corners of the 1977 deed, that is correct, Your
Okay,
Honor.
so Mr. Bindas buys this property. His deed tells him that he has clear title to all the property set forth in that deed, and he hears that there's property development and other property owners may have been had part of their land eminent domain by PennDOT or taken by PennDOT, and so he says, "Oh, I'm going to go to the courthouse and I'm going to go to the recorder's deed and I'm going to look to see if there's a deed." And so he goes through he actually hires somebody to go through the deed books and there's no deed there. So who do you believe? Do you believe the word on the street and that gives you constructive notice? Or do you go to the office in the county that's supposed to have the documents to tell you whether or not you have a lien on your deed? And who do you believe? And so that kind of doesn't seem set right with me, and I get that it's kind of a Hobson's choice about who ultimately bears responsibility for this, but how many property does PennDOT condemn in a 10-year period?
I don't have the exact number, Your Honor, but it would be significant.
Yeah, and how many properties does people like Mr. Bindas buy in their lifetime?
I don't have an answer to that question. I think it was rhetorical, but I understand your concern. But essentially, what we have here is Mr. Bindas in 1977 engaging in type of land speculation. He acquired this parcel, which I will note, the deed, the description of the property set forth in the 1977 deed was 0.04 acres. PennDOT concedes, and I think if you look at the figures that PennDOT attached to its brief, these kind of were zoomed in on the relevant highway plans to kind of give an accurate description of what occurred here. There is a 0.04 acre triangle that all the parties here agree Mr. Bindas owns. That is PennDOT's assertions that is the property description set forth in the 1977 deed. That is what our testimony introduced. And now the trial court essentially said, look, I don't have to examine the question of title of Mr. Bindas because we're going to assume he has the title to the entirety of the property.
Counsel, I'm a little confused. Are you conceding that the plan was recorded or not recorded in a plan book or index?
Your Honor, it's our position that the plan, and as the Commonwealth Court found, it was properly recorded. I believe volume 7, page 14. However, at the time in 2016, at least when the litigation was going on, the only record that was found was the microfilm. Now, I believe that satisfies Pennsylvania law. There is, if you look at footnote 8 in our brief, we cite 2 statutory authority that provide that microfiche, microfilm is an adequate recordation of real property title.
Not if you can't find it. I mean, first of all, the first thing you said was it was properly recorded and there was a book number and a line number, but if it's not indexed, how do you get there?
Well, I think Mr. Bindas' counsel on his arguments said that PennDOT conceded that it was not indexed. That is a little bit inaccurate. PennDOT conceded at the trial court that it's not indexed in the grantee-grantor indexes, and that being not being the requirement until 1964. However, the question here is what is defined as adequate locality index?
Hold on. If it's not recorded in the grantor-grantee index, what index was it recorded in?
This would be what the requirement, the plain language requirement of Section 210 is the adequate locality index. And what you had in that drawer, what was found by the trial court, is that you had the microfilm highway plans loosely recorded by municipality involved.
But there was no index.
Well, the definition of what a locality index, I think, here is in question. That is an issue for this court. And in PennDOT's brief, our position is this is more akin to kind of a Dewey Decimal System, a way of locating and finding these highway plans.
But it couldn't be found. I mean, that in other words, it seems like your argument is it's good enough, while at the same time you're arguing that 1964 was a watershed. In other words, if the post-1964 world is different materially from what went before, then it seems you're conceding there's a violation of the statute here. And then I guess your argument is it's of no consequence and we should disregard because it's just a small piece of land, or because we should put the obligation on him contrary to the obligation set forth in the statute? Or what am I missing?
I think PennDOT's position here is that the Department of Highways 1958 had 4 obligations to meet. And the department in 1958 met those 4 obligations. The additional plain language of the statute requires that the Recorder of Deeds, Washington County in this case, maintain an adequate locality index. Our position is that adequate locality index, while not being a defined term, that it was in fact placed in some type of system that is locatable. And now what we have to remember is,
But how was it I mean, it was unmarked or unorganized, and Ms. Sten, who's a professional, couldn't find it. How is that adequate? How does that comply with the statute?
I think in this case, what we have to look at is the context of the property involved. And the trial court held that a title searcher, now, as I said, I think the 2016 title search is not as relevant as what was done when the property was purchased, because it all goes back to the question of notice. The trial court correctly held that due diligence in a title searcher would have known, given where the property was situated, due diligence would have entailed examining the highway plans, possibly reaching out to PennDOT, which was not done. And it also would have examined the title of the adjacent property owners, which would have turned up the Carter chain of title, which clearly enumerated, I believe, sometime between 1958, I want to say 1972, I believe, is the Carter chain of title, clearly delineates that there was a condemnation action by PennDOT. Unfortunately, the Kohler chain of title did not. However, I don't believe that is fatal to this case. But the question is there sufficient notice in the chain of title or in the Recorder of Deeds office to put Mr. Bindas on notice in 1977? And I believe, Your Honor, that is certainly the case in this.
All right, does anyone have any other questions for Mr. Martins? Want to wrap up, sir?
Thank you, thank you. Now, it's PennDOT's position here that there cannot be a de facto taking because Mr. Bindas has not been deprived of the use or enjoyment of his property, nor any other damage to his property interest, even assuming that he has one. So in conclusion, the department would respectfully request that this honorable court affirm the decision of the Commonwealth Court and the Washington County Court of Common Pleas that Mr. Bindas has failed to meet his burden. Thank you.
All right, thank you both. Mr. Minner, we're going to take a break for lunch, and we will resume at 12:45. Good afternoon. In this appeal by allowance, we address whether a trust was void where it was created by an agent acting pursuant to a power of attorney that was signed by the principal but not notarized, and thus did not meet the statutory requirements for a valid power of attorney under the Pennsylvania Estates and Fiduciaries Code. Please proceed.
Good afternoon, Madam Justice and other justices. I am Todd Jordan of Williams-Colson, and I represent Joseph Koepfinger, a 97-year-old World War II veteran who's actually here in court today. He never thought he would make it to today. Glad he did. What we have, Your Honors, is an irrevocable trust created by an agent under power of attorney. This trust is irrevocable. No principal or income is paid to the principal unless directed by the trustee, and the trustee decided who were the beneficiaries. 5603 says an agent can create a trust. Has to be revocable, income paid during the lifetime of the principal to the principal, and paid to the estate. What the agent did is wrote his will. She put everything into this trust. His will govern nothing because there are no other probate assets. But more importantly, we don't have a power of attorney. The power of attorney was held void ab initio, like it never existed. Mr. Koepfinger in 2016 signed a POA. The first one in, I believe, March of 2016 had dual agents and had a bad notice provision because the notice provision under the statute changed. They went to the bank, tried to use it. Banks don't like dual agents. They want to have both sign off on everything. So later in 2016, the attorney sent Mr. Koepfinger a new power of attorney. Said, look, sign it, send it back, we'll witness and notarize it. And this is in 2016. Didn't tell him that this new power of attorney had language in there regarding the creation of an irrevocable trust. Mr. Koepfinger signs it, doesn't realize there's irrevocable trust language in there, sends it back. The attorney's office then witnesses and notarizes it. That's what makes that power of attorney void ab initio. The legislature in 2014, Act 95, said powers of attorney are important documents, they're powerful. We want them witnessed in front of two people and signed before a notary. Those are more stringent requirements than what's required for a will. Will, only the testator has to sign at the end. For a power of attorney, the legislature made sure there were extra safeguards. In this case, they were not followed. And this is what happens. Without that letter, we would have never known that this power of attorney was void. Because on its face, it's signed, witnessed, notarized. Anybody looking at it would see that looks perfectly fine, but it wasn't. So you don't know just from looking at it, is it valid? For third parties, 5608 gives them protection. If it looks facially valid, they ask if it is, that's enough for a third party to accept the power of attorney as being valid. They don't have to, they can do other inquiries, but they don't have to because it's facially valid. But in this instance, the agent is not a third party. They don't get the protections of 5608. 5608 goes to liability of third parties, not the validity of documents. So she creates a trust using a power of attorney that never existed.
Counsel, can I ask a procedural question?
Yes.
Just to help clarify what happened here. The original judge on the case
Judge Durkin.
issued an order declaring the POA invalid, correct?
Yes.
Then there was a subsequent motion to declare the trust invalid as void ab initio.
Yes.
The trial court judge, however, denied that motion.
Yes and no. Judge Durkin at that time was not sitting on the bench. Judge O'Toole signed that order. There was no hearing.
Okay, but there was a judge who looked at that motion and denied it.
Correct, without a hearing.
Understood. There was no appeal from that.
From the denial of the motion?
Yes.
Correct.
Okay. Then a period of time goes by and another judge is assigned to the case.
Yes.
And that judge then declares the POA, declares the trust void ab initio.
Yes.
What was before that judge that allowed that third judge to revisit the ruling that was made by the prior judge in denying the motion?
The initial declaratory judgment action was still pending. That was filed by Margaret Koepfinger, the trustee. She initially filed a declaratory judgment action that determined the trust was valid and the POA was valid. That was still pending. And that's what Judge McCarthy ruled on.
Okay. So there's no inconsistency with what Judge McCarthy did he ruled on POs?
No.
What did he rule on?
After briefs and arguments, he ruled on the declaratory judgment action.
Okay.
So there was actually a hearing, argument. The motion to terminate the trust was just filed, no argument, no nothing. It was just of record. Again, Judge Durkin's case, Judge O'Toole signed it because she was unable to. So that was the procedural point to there.
Thank you.
Mm-hmm. Yes.
In the declaratory judgment action, there was a request for a declaration that the trust was valid?
Yes.
Okay.
And the power of attorney was valid. So those were still open items for ruling, and that's what Judge McCarthy ruled on.
Well, wait. Wasn't there an initial ruling by Judge Durkin that the power of attorney was void ab initio?
Yes.
Was that on the declaratory judgment action?
As part of, yes.
Okay.
Excuse me. Because we found that letter and everything derived from that power of attorney.
I'm just talking about the procedure. So then she rules on that. There's still the declaratory judgment action pending that asks for a declaration that the trust itself was valid. But instead of working within the context of the declaratory judgment action, you or someone else on behalf of your client filed a different motion to have the trust declared invalid.
Yes.
But it was part of the motion was part of the debt judgment action.
It was
It's not on the same docket.
It's all in the same docket. It was a subpart of that action. Because again, in the declaratory judgment action, they asked for the power of attorney to be declared valid and the trust to be declared valid, two separate counts.
Okay, well then, back to Justice Brobson's question. How did it come to pass that there was another proceeding dealing with the validity of the trust if a prior judge had already signed an order denying a declaration that the trust was invalid?
There was nothing as to a declaratory judgment action, a hearing, or anything else. There was just one hearing as to the validity of the power of attorney, nothing else.
Well, but that may be a reason to that may be a reason to have appealed the denial of the motion by saying it was entered without an order, or was entered without a hearing, we should have had a hearing, all that other stuff. And again, I'm not trying to hijack your argument on arguing the substance. I'm just trying to get to how we got to this point. The trial court ruled on the validity of the POA and the debt judgment action by motion,
Yes.
issuing the order. Then a follow-up motion was filed for the disposition of the other issue in the debt judgment action, that being the validity of the trust. That motion was denied, perhaps in error, but it was denied. Period of time goes by, there's a status conference of the attorneys, and the next thing you know, the new judge is ordering up briefing on the very issue that seemed to have already been resolved by the prior order.
again, the prior order only dealt with the power of attorney.
No, there was a second order that denied the motion to declare the trust invalid.
Yes, based on the argument that if the POA never existed, how could you have a trust?
Right. So that was decided by one judge and then decided by a subsequent judge differently.
Well, I don't think we had a full hearing on the merits.
I know that's a good argument.
Right.
If you were appealing that first order, but I'm not. I would love you to tell me how the law of the case doctrine doesn't apply here, and the coordinate jurisdiction rule doesn't apply.
Because, again, I believe it was two different issues. Sometimes in orphans court, you might have 3 or 4 things going on, and the court rules on one, not the other. So I think if we had filed an appeal at that point, it would have been interlocutory, because the declaratory judgment as itself wasn't finished. Only one part of it was.
The 2 parts were, you had an order declaring the deck judgment action was about declaring the POA valid and declaring the trust valid, right?
And there were 2 other counts in there, yes.
Okay. But then in the declaratory judgment action, the first judge adjudicated the issue in the deck judgment action about the validity of the POA and said it's invalid in an order.
Right.
Then, consistently with how the judge disposed of that aspect of the deck judgment action, a motion was filed to now issue a ruling on the other part of it dealing with the trust, motion to declare the trust invalid, and the trial judge said, no, denied. I'm not going to declare it invalid. I don't understand how that didn't end the case.
Because there were also an accounting was being filed at that time, objections were being filed as to.
And if you would have gone in front of Judge McCarthy to deal with those issues, that would have been, seems to be valid. But somehow, some way, Judge McCarthy revisited at least the one prior issue that was already decided by the court. And I'm trying to figure out how he did that without violating the law of the case doctrine.
I haven't thought of it that way, because for me, it was always ongoing. What happened with Judge Durkin was a shame with the stroke, so that kind of stopped things. We filed a motion to terminate, just filed it, showed up in court, nothing happened, and then about a week later, we get that order signed by, I think, Judge O'Toole on behalf of Judge Durkin. So, again, that's an unusual circumstance.
Did he request briefs?
Nothing.
Or argument or anything of that nature?
There was nothing on that motion to terminate the trust. I mean, our argument at that point was, if the power of attorney doesn't exist, you couldn't create that trust.
Well, that's what your argument is.
That's what I'm arguing now. We've gone through appeals.
I mean, that was your argument
Yeah,
before Judge
that was in our motion
also.
to terminate the trust.
Right.
And then the other, not problem, but is we were not able to argue before the Superior Court because of COVID. It was just submitted on briefs. There was no oral argument at that time. So we couldn't even argue then.
Well, in any event, did anybody argue the law of the case before today?
I'm not sure if they have it in their brief somewhat.
Your Honor, I don't mean to interrupt, but I can answer that question.
Well,
I'll wait.
Yeah. But I don't think that was even addressed by the Superior Court, the law of the case. They just found 5608 applied, Vine did not, and that it was a facially valid POA, therefore the daughter could create this irrevocable trust. Which again, I don't believe under 5603, you can create an irrevocable trust. That's not a permitted power under the statute. Then the other part of the question presented for review is, what do we do with a power of attorney that is not executed in conformance with the statute? Most of the times, we will never know that it wasn't. We'll see 2 witnesses and a notary. We just happened in this case to get the letter saying, sign it, send it back, we'll witness and notarize it. Unfortunately, I have another case where it wasn't properly executed. Attorneys take shortcuts. They don't show up, they just have somebody go, one witness, maybe a notary. then they sign it when they are back at the office. So this isn't a one-off. They're out there.
So your argument is the terms of the statute must be strictly complied with, or any actions taken under the power of attorney are void?
Yes, but then there's the caveat of a third party under 56.
But you're not representing a third party.
No, I'm not.
I mean, your point is you're here on behalf of the principal.
Correct, to say he should have the option for any actions taken by the agent to disavow them.
Well, that's different than saying that the trust is void ab initio because the power of attorney was void ab initio.
Well, under the power of attorney, if the agent had paid his real estate taxes, his medical bills, normal expenses, we wouldn't be here. We wouldn't have challenged those actions.
Well, that's not your best argument.
Well, but
if I might point that out, I mean, either the trust is void or it's not.
we're saying it's void because that's something not permitted, because he didn't authorize that.
No, I thought you were saying it's void because the power of attorney is void.
I am.
Okay.
But I'm saying because the POA is void, the trust created by that POA is also void. That's the void ab initio doctrine.
Correct.
The practical matter is these POAs are out there. They're used every day. Normally there's not a problem. We can't void every transaction that's done. The principal under equity should have the right to say, no, you shouldn't have sold my house. You shouldn't have created a trust. I want to challenge those and undo those.
But are you saying that you still have the right, that the power of the POA still can carry some force and effect in other issues that you don't, or that you do agree?
Not going forward, but things that might have already happened. The principal can just reaffirm some of those transactions. An accounting is filed, principal looks at the accounting, and then can file objections to what they object to. Because
I'm confused. So you're saying that the POA is void ab initio, which means it doesn't exist. So then how do you support your argument, but it exists in cases in which you affirm it to exist?
Because by the time, in this case, that we found out that it was void, there had already been transactions that occurred, including...
But the void goes back to its inception.
It does.
So then any act on behalf of the agent is a null. Yes or no?
Yes. Those are all void.
Let's stop there.
Yeah, okay, they're all void. It's just, they're not challenged. Because they've already occurred. 5608 then comes in for third parties. A principal's not going to challenge those transactions. If that's what had happened here, we wouldn't be here. But this is an extreme case where she got the POA, created this irrevocable trust, put all of his assets in, and has total control over all of his assets.
But we don't care about that. I mean, the issue before us is, I thought, pretty straightforward until just a couple of minutes ago. I mean, the question is, if a power of attorney is void ab initio, is a trust created under it also void ab initio? Whatever the practicalities are of how that works out in an accounting or otherwise is actually just not before us.
Okay.
I mean, you're asking us to say that the trust was void ab initio. If that has repercussions down the line, then it's just something you're going to have to deal with. But if we grant you the relief that you're requesting, then the trust is void ab initio, not but what if and but third parties. I mean, that's somewhere down the line from where we sit today.
And we do want the trust voided because he never wanted that trust. That's why as soon as he found out about it, there was discord between him and his daughter, which precipitated the filing of the declaratory judgment.
Okay, anything that you haven't already told us, sir?
No.
All right, thank you very much. Let's hear from Mr. Ronaldo. Good afternoon.
Good afternoon, Your Honor. May it please the court, my name is Richard Ronaldo, representing from the law firm Jones, Gregg, Crean, and Gerace, representing Margaret Koepfinger, who is the appellee in this case. Your Honor, I'd like to begin by clarifying some things that came up during the appellant's argument. Several of you asked about the question of the law of the case. With respect to the question of the motion to terminate the trust, which was denied by Judge Durkin in an order signed on her behalf by Judge O'Toole. The answer is that that was one of the three issues we presented to the Superior Court on appeal, was whether the law of the case precluded that issue. The court on, I believe it's page 6 of the opinion, did not reach the issue of the law of the case because we prevailed on the first two issues. So the question of the law of the case, in light of that particular order, has not been decided by the Superior Court.
Did we accept aliquotter on that issue?
Well, there was nothing to appeal. You accepted aliquotter solely on the trust issue because the Superior Court did not decide the law of the case when it reversed the Common Pleas Court. And the Superior Court sent it back to the Common Pleas Court for further proceedings consistent with the opinion for reasons that I'm going to talk about in some detail, because that is another procedural problem that perhaps ought to be clarified here.
So if you would not prevail here, then
it would go back.
You would want to go back to the Superior Court to have them address the law of the case issue.
Well, if my recollection of appellate practice is correct, Your Honor, and God, Lord knows yours is better than mine, I would think that it would need to go back to the Superior Court to have the Superior Court reach the question of law of the case, yes. But we have a threshold issue procedurally that's even more difficult. Contrary to what the court may have heard, there is no order by Judge McCarthy declaring the trust void. It doesn't exist. And the Superior Court already noted that in its opinion.
I'm reading an order from Judge McCarthy dated January 22nd, 2020, and he says the prior determination that the trust was void remained undisturbed by the order of June 10th, 2019.
Exactly, Your Honor. That's on page 694 of the record in Volume 3. The problem with Judge McCarthy's order is that there is no such prior determination at all. In fact, Judge McCarthy is referring to Judge Durkin's prior order in February of 2019 declaring the POA void, not the trust. And the Superior Court pointed that out in its opinion and said that there isn't any such order. What he says is the June 10th order, Your Honor, was undisturbed. Well, the June 10th order was the order denying the motion to terminate the trust. So there is no motion, there is no order before this court, and there was no order before the Superior Court terminating the trust.
But there was a decision terminating the trust.
I didn't see it, Your Honor, and I don't think you will in the record either. I'm looking at the Superior Court opinion, and if the Superior Court specifically says on page 5 of the Superior Court opinion, in Daughter's first and second issues, she argues that the Orphans Court erroneously terminated the trust by failing to consider 5608 in effect at the relevant time. She also contends that the court erred by finding that the trust had effectively already been determined to be void due to the court's prior determination that the 2016 POA was void ab initio. We agree with both contentions and vacate the Orphans Court's order.
But that goes to the question, like, you appealed.
Yes.
So what
We appealed.
did you appeal? If there was never an order terminating the trust, what did you appeal?
Well, there were 3 issues we appealed.
No,
because
we don't appeal issues. We appeal orders. What?
We appealed the January 22nd order
Which said
because
what?
he declared that the prior order terminating the trust was undisturbed, and we said that was erroneous.
Okay, so you appealed the portion of his order that recognized, perhaps incorrectly, a prior order that he says declared the trust invalid.
That's correct, Your Honor.
And
that's one of the 3 things. And the second was the application of 20 PACS 5608. The third was the law of the case, which I've already addressed, which the Superior Court didn't reach. So, with all due respect to Judge McCarthy, he misinterpreted Judge Durkin's orders. He did not personally declare the trust void. There is no order actually declaring the trust void. What the order that we appealed said was that the trust had already been declared void, which it hadn't. And the Superior Court agreed, vacated, and remanded for those very reasons. Having kind of tried to clarify the procedural posture of the case, there is another issue with respect to the fact that we have a void ab initio power of attorney, and pursuant to that power of attorney, before it was declared void ab initio, my client created a trust, which I think it's very important to note that the power of attorney at issue was created by the firm Zachariah Brown, who was Mr. Koepfinger's attorney at the time, not my client's attorney. Mr. Koepfinger's attorney created the power of attorney, sent it to my client, okay? It was signed by Mr. Koepfinger. My client had no reason to think that it hadn't been, and in fact it had been. When she signed it, it was notarized, and the notary attestation says that Mr. Koepfinger personally appeared in front of her. Oh, I'm sorry. Did it go off? That Mr. Koepfinger personally appeared in front of her, and signed off on the power of attorney. In other words, there's no question that based on information which my client received from Mr. Koepfinger's attorney, Thomas McCaffrey, and this is undisputed, by the way, Your Honor, Thomas McCaffrey of Zachariah Brown testified, and his testimony is in the record in Volume 2 at page 398 and 411, that he never told my client that there was anything wrong with the power of attorney. He sent it to her.
Does that matter?
Well,
you're not suggesting she's a third party.
Actually, Your Honor, I'm suggesting that she's an agent entitled to that benefit, not as a third party, but I'd like to turn the court's attention to 20 PACS 5608. 5608 used to have sections A and B talking about third party liability and immunity. That was amended in 2014 to overrule In re Lamb, In re Vine, based on a legislative reversal. Now, sections C and D are the relevant provisions, and I respectfully submit that section C is not limited to third parties, far from it. Section C says, a person who in good faith accepts a power of attorney without actual knowledge that a signature or mark of any of the following are not genuine may, without liability, rely on the genuineness of the signature or mark of 1, the principal, 2's not material really, a person who signed on behalf of the principal, 3 is not really material here, a witness. 4, a notary public or other person authorized by law to take acknowledgments. You notice that it doesn't talk about an agent there. That's because a person is including an agent there, because if you look at section D, the next section on immunities, it starts the same way. A person who in good faith accepts of a power of attorney, but then it goes on and it says, as if the power of attorney and agent's authority were genuine. That's the section that deals with third parties that Mr. Jordan was talking about, not C. My client is entitled to rely on that particular power of attorney at the time she got it. And as such, she was entitled to create the trust. That doesn't make the trust void ab initio. I mean, in fact, as a practical matter, undoing the trust would be a nightmare at this point. But that's, of course, not the issue before the court.
Let me just back up a little bit here.
Certainly, Your Honor.
We have an unappealed ruling that the power of attorney is void ab initio.
Correct.
Okay.
You have an unappealed ruling that, you also have an unappealed ruling that the trust is not void.
Well, I don't know about that. I mean, I just sort of took a brief look at Judge McCarthy's opinion. I mean, he clearly intended that this trust be declared void as a result of the power of attorney being void ab initio. But we'll get into the weeds of that factual dispute. But the issue before us is whether or not a trust created under a power of attorney that is void ab initio is also void. Your argument is
that it is not.
Because
it may be voidable.
It doesn't. So you're saying that the statute which requires the notarization doesn't actually mean anything?
Not at all.
Well,
not at
what
all.
What does it mean? I mean,
well, it means it.
If we have the principal here who is saying this is a void power of an attorney, if a principal can't enforce the statutory requirements, who can? Who can? No one.
Well, Your Honor, I'm not suggesting that a principal can't do that. What I'm suggesting is that at the time my client had this power of attorney and was creating the trust, she was entitled to rely on a power of attorney that was facially valid. It only became known later that there was a failure by Mr. Koepfinger's attorney, Mr. McCaffrey, to actually have Mr. Koepfinger sign the power of attorney in the personal presence of the notary who worked in his office. And in fact, he did it secondly. And my client under 5608C is entitled to rely on that, was so when she created the trust. The trust is
to the detriment of the principal.
Your Honor, I'd respectfully respond that there hasn't been any detriment to the principal, but that's probably not the question you were asking.
It isn't, actually.
I know.
We have a statute that has requirements that fall into place in order to create a power of an attorney. We have
Correct.
A ruling by a trial court that's unappealed that the power of attorney is void ab initio.
Yes.
And your position is, even when the principal attempts to enforce the requirements of the statute for the creation of his power of attorney, he is unable to rely on the statutory requirements in order to present the position that any action taken by the agent under that power of attorney is also void ab initio.
That may be a little further than I'd be willing to go, Your Honor, but what I would say is, yep, I'm sure you understand why.
Well,
but what I'm saying, I understand. What I'm saying is that he can move to terminate the trust, and the Superior Court already noted that in its footnote to its opinion on remand if he wants to. He can do that. But the question is whether the trust was initially void, whether my client was entitled. Can he void the, we do have a void ab initio ruling, and that means that they weren't followed. I understand that. But on the other hand, we also have a valid trust which was created, and that's, I guess that's the issue you're going to ask yourselves
Is
to
it a valid
decide. That I think that although it may be a voidable trust, it is current. I don't think that because she was entitled to act at the time she created the trust, and she's the trustee, and she's entitled to do that.
Yeah, but you're making it very personal, right? Because your client was entitled. I don't think there's anybody disagreeing that your client got a POA. There's at least your belief that your client acted in good faith, in reliance on the POA.
Yes, Your Honor, and that's what's important about it. Because
But none of that. No, I'm not sure that is important because there's no detrimental reliance. Your client didn't adversely affect her circumstances to her detriment. If this gets blown up, she suffers nothing.
Actually,
it gets blown up, and because everything is supposed to be in favor of the person who's the one who created the power of attorney.
Actually, Your Honor, if this were to get blown up, it wouldn't be fair to say she didn't suffer anything, because if you read the reply brief filed by the appellant in this case, there's no question that what they're pointing toward, and he says it, is a surcharge, charges against my client, so forth. So my client will most assuredly have
Your
harm.
client has a defense under the statute. I mean, you're taking the position that she's not a third party. I just have I note the difference between person and third party and all those kinds of things. But as I analyzed it, in a surcharge position, she has your reliance argument. Purely and simply under the statute. I mean, I don't predict what's going to happen, but certainly, pardon me, everything you've said in the context of this argument goes to your point that she did everything she could have done to assure that she was operating under a valid power of attorney. And as I read the statute, that's a defense to liability, which is what a surcharge action would be in this context. See, I see that as a totally different issue vis-a-vis your client. And
I agree.
I troubled with the choice of the word person, a person relying on it. I mean, who would that be? I mean, if they meant an agent relying on it, they could have said agent.
It could have been any third party, any person. What I'm saying is the difference in the statutory language between subpart C and subpart D, where agents are mentioned specifically in subpart D, meaning that the statute clearly is referring to what you're characterizing as third parties. The absence of a reference to an agent in subpart C implies, to me at least, in attempting to construe the statute, that agents are included in that group.
And that could very well be, which goes back to my point, and I think the point that Justice Robson made, this detrimental reliance, all of those kinds of things, that doesn't fit into the issue before us. It may very well fit into an issue down the line in terms of liability in a surcharge petition or something of that nature. But why... Let's assume for the moment that your client's, good faith belief that she was acting, and let's just say that that has no place in this. What's your other argument that a trust created under an invalid ab initio power of attorney is still a valid?
Well, at the risk of deferring the answer to your question, and I do intend to try to answer it, I think the first thing I'd like to say in response is that at this point this court doesn't have an order in front of it terminating the trust, and neither did the Superior Court. So that, in fact, if I understand the procedure correctly, and I may or may not, if I understand the procedure correctly, the Superior Court should be affirmed because what it found was absolutely correct. about the absence of any such order, and then that would go back to the trial court. And if Your Honor is correct that Judge McCarthy intends to declare the trust void, then further proceedings consistent with the opinion would come in front of him.
Do that, though?
No, Your Honor, I don't think it does. It says that there was a prior determination that the trust was void, and there wasn't one. He was wrong. He wasn't on the case at the beginning. It was Judge Durkin, and there is no such prior order, and the Superior Court correctly pointed that out. So that there is no order before this court on appeal where the trust was declared void. And what you're suggesting, Your Honor, I guess, is that this court, and I do recognize this is a matter of first impression before this court, that this court should, in the first instance, make that decision. But speaking that way, I think the entitled to rely on it, and this is the answer to the question you actually asked, Your Honor, I hope, is that because of Section 5608C, where she's entitled to rely on a facially valid power of attorney that she has no reason to believe is defective, and the evidence is clear on that, because she received it from her own father's attorney, the principal who had him do it, okay? Because of that, she is entitled to rely on it. And if she's entitled to rely on it, she's entitled to take actions pursuant to the apparent authority. Is that me? Okay, the apparent authority which she has. And one of the actions she took, and it's not the only action she took, there are other things that aren't before the court, but one of the actions she took was to create the trust. And that trust she created at a time she had the apparent authority to do so. And if it was subsequently declared void ab initio, I don't think that's sufficient grounds to declare the trust void ab initio, because she was entitled to rely on it and take the action she took at the time.
It appears to me that that statute may be referring to a situation where, let's just take, for example, she did business with PNC Bank based upon this, the trust that she created. PNC can't look to her and hold her liable for any damage it may occur because the trust is void ab initio.
Well, Your Honor,
It
PNC...
refers to her liability. I mean, that's what this is dealing with.
Well,
She could act without liability.
PNC wouldn't have to do that anyway because of Section D. They're immune as a third party. But, well, anybody under D.
And they cannot look to her as a liable party for actions that she took, believing that the power of attorney was valid and gave her the ability to create the trust.
Agreed.
That doesn't have anything to do with the principal who's attempting to enforce the requirements of the statute. I'm just saying straight out, this is just not valid. The power of attorney wasn't valid, and anything she did under it wasn't valid.
Well, if that's true, and the Superior Court said that Mr. Koepfinger can go back to the trial court and file a motion, and ask the judge to decide whether the trust is void, then that's what should happen. I respectfully disagree because I believe that the trust was void, was valid when it was created. But what I'm suggesting, Your Honor, is that that's not quite what's before the court.
Except when you were before Judge McCarthy, you made precisely the same argument you're making to us today based upon 5608, and he rejected it, correct?
I wish I could answer that question, but I was not in front of Judge McCarthy, so I don't remember what the argument was, and I apologize.
His opinion would reflect that the argument that we're hearing now was made before, which leads to the conclusion that he may have decided on his own that the trust was invalid, but...
Your Honor, I don't think if he decided on his own that the trust was void, he didn't say that in his order.
Did you file an answer to the petition for allowance of appeal that was filed with us?
We did.
I don't refresh my recollection.
We did, Your Honor.
Okay, thank you.
And If the court has no further questions.
Any other questions? No, thank you
And
very much.
The only thing I'd like to add is that we respectfully ask that this court affirm the decision of the Superior Court that was issued in this matter.
Thank you very much.
Commonwealth of Pennsylvania versus Ricky McGinnis, representing Mr. McGinnis, Mr. Craig Cooley, representing the Commonwealth, Mr. Daniel Vernacchio.
Good afternoon. In this discretionary appeal arising out of a prosecution for child sexual assault, we consider whether the trial court erred in refusing to allow the defendant to present expert testimony to the jury regarding the concept of false memories in children, and whether certain interviewing methods or counseling can result in a child's inability to distinguish between real and false memories. Please proceed.
Good afternoon, Madam Chief Justice and the court. My name is Craig Cooley. I represent Ricky McGinnis in this action, and I'll get right to the point. The answer to the question presented is yes. Generic false memories expert testimony presented in a child sexual abuse case by the defendant for the sole purpose of educating the jury about how false and or distorted memories are created in children is admissible. And
Is it admissible in any other states? Have you done a statewide, a countrywide survey, state by state?
I have, and in my opening brief, the reply brief, and in the amicus brief that the Innocence Network and Pennsylvania Supreme Court, Pennsylvania Innocence Project filed, yeah, we cited several cases. We cited the Barrow case from Georgia. We cited Sargent from New Hampshire. There's an excellent case, Carver, out of Michigan. There's a DeLone case out of Texas. In each of those cases, a lot of those cases deal with the question of whether the defense can introduce an expert to talk about the proper techniques in interviewing children.
Yeah, in terms of being directly on point, did you identify any states that have addressed this issue?
The two cases that really address that issue, at least based on my reading of those cases, is the DeLone case out of Texas and the Sargent case out of New Hampshire. Both dealt with, in DeLone, the defendant in that case wanted to present Dr. Elizabeth Loftus, and this court cited Dr. Loftus' research repeatedly in Walker. And so they, in that case, the defendant wanted to have Dr. Loftus talk about false memories, and specifically how they're created and what variables, what factors, what communications can produce false memories. And in DeLone, that was, the accusers in that case were teenagers, but still, it dealt with false memories. The Carver case, the court really should read the Carver case out of Michigan. That one is very detailed. It's an ineffectiveness claim where, the defendant claimed that trial counsel did not present an expert to talk about child suggestibility. But if you read the opinion in the evidentiary hearing that was had in that case, the expert really hammers home everything that's pertinent in this case. Right? In that case, it was the uncle, who lived downstairs, and the child was 4, it was preschool age, but there's a lot of testimony in there that the Michigan court, the trial court, and the Court of Appeals accepted. And because you can't, if it wasn't acceptable, trial counsel wouldn't have been ineffective. So I would urge the court definitely to focus on that one.
Go ahead. Sorry to get you off track.
No, that's much easier when there's a conversation going back and forth. But But again, the trend across the country is to admit this type of evidence. And if you look at those opinions,
Well, wait a minute, you just told me there were two cases, two states. What's making up the trend?
well, the trend is if you look at the cases where defendants want to introduce expert testimony to educate the jury about what techniques or communications can create false memories, all these cases go to false memories. If that makes sense.
Well, it does, although we're dealing here with a very specific question, testimony regarding false memories. I mean, there are broader categories of testimony that is permitted, such as what we addressed in Walker with the value or no value of eyewitness testimony. So there's a range of these, but my question was with respect to specifically false memory testimony.
Yeah, the two I would focus on is DeLong and Sargent and again, Carver's an ineffectiveness claim, but a lot of the evidence that they rely on and accept, establishes that, false memories testimony is generally accepted. It's built on decades of cognitive psychology, again, which this court really hammered home in Walker, and which, I'll eventually get to, or if the court has questions about it, we can discuss Walker.
What were you relying on then when you just said there's a trend?
Well, those cases in particular, when the question of false memories comes up, when a defendant wants to introduce some sort of expert testimony to discuss false memories or distorted memories, I'm aware of only one state, I believe it's Maine, that prohibits an expert to come in to talk about the proper interviewing techniques. But all the other states that have addressed the issue of whether a defendant can challenge via expert testimony on false memories, be it how false memories produced from improper interviewing or suggestibility or improper communication, all those cases have admitted that type of testimony. And they've admitted it because it's generally acceptable, it's reliable, and it's beyond, and this gets me to my second point, I guess, is it's admissible because if you look at the rules of evidence in Pennsylvania, you have 401, right, relevance. Here in this case, it would absolutely be relevant because in this case, the sole evidence against Mr. McGinnis is an uncorroborated memory or claimed memory from JM. And I'm going to refer to the child as JM just for protect his identity. And that's it. So the question in the case really came down to is this a credible memory? Is this memory actually from an event that occurred, or was it produced some other way?
But the memory we're talking about, just incidentally, was consistent as conveyed by the child from the time he was 5 until the time he was, 10 or 11?
I would, no. I'll be blunt, no. If you look at the forensic interviews, and this is a remarkable case in many ways, given what transpired. So let's go back to late January 2013. Mom takes the child to Children's Hospital, claims that JM said something to the effect that Dad put a hole in my butt. Okay. So a forensic interview was scheduled. I believe that was on February 11th, 2013. And if you look at the summary of that forensic interview, which I cut and pasted and put into the brief on page 8, it says these things, okay? It says, JM, quote, can't understand the rules of the interview. JM got his age wrong, didn't know his date of birth. JM provided little or no information regarding school activities. And here's what he reported. He reported things like, quote, I do not like Dad anymore. He says, Dad cusses too much. And then this goes to your question, Justice Todd, Chief Justice Todd, is what was he alleging? In this first narrative, he's talking about a knife incident. Dad used the knife from the kitchen. He pushed too hard and hard all day. This took place on more than one occasion. It took place in the living room, in JM's bedroom, and Dad's bedroom. JM said mother witnessed what happened. So we're talking about a knife. There's no word of penis at all, or anal sex or anything in this first narrative.
Counsel.
Yes.
Counsel, if I may.
Sure.
The language you're using is reflecting rule of evidence, 703, correct? Yet the statute before this court is the statute that the General Assembly had passed using titled expert witness in certain criminal proceedings. Where in the statute 5920 is it a requirement that it has to be generally accepted in the relevant field as defined in our rule on expert testimony?
You're talking about the actual text of 5920?
See, we're talking a statute as a rule, and I find the trial judge, somehow immersed a rule of evidence into language. She added language to a statute that it doesn't have. The statute in and of itself specifically defines that the court may define the expert or permit the expert, provided that expert has specialized knowledge beyond that possessed by the average layperson on the witness's experience with, for example, specialized training or education in criminal justice, behavioral science, or victim service issues related to sexual violence and the impact of sexual violence. So the question I have, I'm waiting for the Commonwealth, is why or how is false witness testimony, false identification testimony, how is that not relevant pursuant to 5920? It seems like we're all being misguided by applying the factors of a rule and trumping a statute. The last time I looked, statutes trump rules. So I guess the question I have is, why are you arguing a rule-based argument when your argument lies in the statute?
Well, two reasons. One, the question presented that the court asked me to brief, I think, required me to address Rule 702, 401. But I agree with you. I think the trial court got it wrong.
With all due respect, the issue granted says whether generic false memory expert testimony in a child sexual abuse prosecution, which the defendant is presenting solely to educate jurors about how legitimate and false distorted memories are and can be created in children, is admissible at trial. There's no reference for Rule of Evidence 703. This is a reference relevant to the statute regarding experts in in sexual abuse. That's a very discrete legal issue, as our Chief Justice Emeritus Saylor would often state. So I would like you to address, how does your argument fit within that statute for which is the issue before this court?
Again, I'm a little bit confused. You're asking me to address how it's admissible under 5920? It's, well, if you look at...
Judge Rangos indicated that she denied it because it's not, the methodology is not generally accepted in that field. That's off the mark. That's a rule of evidence, not the statute. The statute provides its definition. Tell me how your testimony fits in within the requirements of the statute, that being 5920, indicating that your witness has some specialized knowledge beyond that possessed of an average person based on your witness's experience with specialized training or education in criminal justice, behavioral science, or victim services issues relating to sexual violence. That should be an easy one for you. I'm throwing you
I will answer it. The easiest answer is to refer to the dissent from Judge Collins, because she says that, Jones. No, I was getting to Jones eventually. But yes, I agree. Jones, I believe, answers the question, because in Jones, the facts in Jones are pretty straightforward. Another child sexual abuse case. Prosecutor put the child on the stand. Trial counsel was able to effectively impeach her with several inconsistencies. So prosecutor puts Detective Horwath on the stand and really try to rehabilitate her credibility. And, you know, it wasn't about false allegations. It really transformed into a memory issue. So he asked a detective who has dealt with sexual abuse cases in his experience and training whether, you know, a child alleging ongoing sexual abuse, I think was the way they worded it, do they have problems recalling issues? And, you know, I briefed this pretty thoroughly. I think it was my first argument I briefed, is that, you know, Jones answered the question. The way this court addressed it, the issue in Jones really was it an opinion or lay witness testimony? The court said it was definitely opinion testimony. And, you know, they granted a new trial because, you know, he wasn't qualified, that the Commonwealth did not properly qualify him. But the important thing that this court said in that is that detective, had the Commonwealth properly qualified him, he could have talked about an accuser's inability to recall dates. And that goes right to memory. They said that was specifically appropriate under 5920.
Can I follow up Justice Dougherty's question?
Sure.
His question raises, I think, 5920 to mind. And of course, 5920 abrogated, at least in relevant part, our decision in Dunkel. And yet, what remains, notwithstanding the intervening statute, is our Dunkel case law that ties your hands behind your back. In other words, the Commonwealth, pursuant to 5920, is allowed to bolster its witnesses' credibility with expert testimony explaining behavior by victims of sexual assault, reporting, etc. But you, still ostensibly bound by Dunkel, cannot call an expert to testify about the possibility that in some hypothetical child, false memories can be created by suggestibility or whatever. And I take it, as I read through these briefs, that is at least part of the issue before us, is that in this post-5920 landscape, is the disability on the defense in the per se bar on admissibility any longer viable, given what the bolstering 5920 allows the prosecution to do. Is that a fair characterization, or am I off?
No, you're 100% correct. It's the playing field, again, is, I think, been tilted to the Commonwealth's advantage. Because, I mean, and I briefed this thoroughly in the pleadings, is if you look at what the Commonwealth did in this case, let's be honest, they put on Jamie Mesmer for one reason. They did, to bolster JM's credibility. Because if you look what ADA Hickton did, she gets Mesmer on the stand and says, well, tell me about the physical manifestations that children with sexual abuse present with. Well, anger, you know, aggression, lying, deception, bedwetting. And all right, so, but she didn't specifically talk about or opine about the credibility of JM's alleged memory.
Well,
but she couldn't.
And you weren't seeking to opine directly on JM either. These were both people that presumably could, by hypothesis, educate a jury. And the problem you're pointing out to us is that while the prosecution is empowered to do this, the trial judge felt that the extant Dunkel-like case law made it inadmissible per se for you. Isn't that the issue?
That's absolutely, yes, that's correct.
Yeah, and I understand the per se bar issue. I'm struggling with why there should be a per se bar against this type of evidence rather than handling it in the normal course of Fry or whatever. It seems to me that that's the appropriate way to deal with this. But on 5920, and maybe I disagree with you on what I agree that it seems like the General Assembly intended to favor prosecution witnesses with 5920, but they can do whatever they want. They're the General Assembly. And it seems to me that they wanted to create this statutory basis to allow this testimony to avoid a Fry situation, to completely get around Fry and say, we are making a policy decision that this type of testimony is permissible. The problem I have with your testimony, though, is it doesn't fit very neatly into what the General Assembly has allowed in 5920, because that 5920 testimony all assumes a victim of sexual violence, assumes the impact of sexual violence, and assumes that there's a victim. Your client's position is there is no victim. There was no sexual violence. And your witness, all their testimony is not based on the actions of a victim of sexual violence. It's based on the actions of someone who is making it up. And that doesn't seem to be what 5920 covers. It may very well be a good reason to put the testimony in response to a 5920 expert, but I'm not sure 5920 itself encompasses those types of witnesses, and tell me why I'm wrong.
I would refer to Jones. I think if a detective can go in and educate the jury as to why an accuser, the word victim is sort of, you're preempting. After you're convicted, we can use the word, that's just me as a longtime defense attorney. The accusers, is claiming that, they were sexually abused, and here comes the detective to say, here's why accuser A is unable to consistently provide a narrative, a correct or an accurate narrative. And in my experience, their memory is impacted for X, Y, and Z reasons. In that case, you're talking about memory. You have a detective coming in who really has no cognitive behavioral background, right? But under Jones, this court said it was appropriate, if he was qualified as an expert, to go in there, meaning at retrial in Jones, that detective, if they qualify him, he can literally tell the jury, here's my experience. They have memory problems. And that
Jones says that's
appropriate.
Appropriate under 5920.
Yes.
That 5920 can encompass alleged victims of sexual abuse.
Every victim, we have to make this clear. Before conviction, they're all alleged victims.
No, I understand.
So the word victim is, the General Assembly simply didn't put the word alleged.
I know, but that's where maybe I'm just being, maybe I'm being trying to hone too closely to the statute. It seems to me that they were trying to encompass evidence that person comes in and says, oh, sometimes victims of sexual abuse delay reporting. Sometimes victims of sexual abuse have memory problems, and it takes therapy and a maturity and things like that to come forward. That would all seem to be clearly 5920 evidence, because it's showing you about how victims of sexual abuse react. Your witness wants to show how non-victims of sexual abuse act and how they can somehow get false memories placed into them. I understand everybody's an alleged victim, but the General Assembly didn't say that, and it seems they could have said that.
I differ. I think number 2 specifically said, witness may testify to facts and opinions regarding specific type of victim response, and that evidence is admissible to say that the child was prepped or met so many times with certain advocates that the victim's response is brought on by an outside influence. That's permissible under the statute, because I actually thought very similar to Justice Robson until I looked at the history of the statute. But that being said,
We'll continue to duel about that.
No, I think if your suggestion is that the General Assembly is using the word victim to already be judge and jury, saying that any testimony, any accuser who is the lead complainant in a prosecution is already a victim, that's unconstitutional.
No, but I agree with you that it seems to be putting the rabbit in the hat. If the General Assembly is specifically allowing this type of testimony, I agree with you. It seems to be, if you allow this in front of the jury, to have an expert talk about victim responses, I think the jury is going to be like, oh, why am I hearing this? This must be a victim, and therefore I must decide. I agree with you, but that may be a basis to allow you to present the evidence you want to present. I'm just not sure it falls in 5920.
The only way it doesn't fall is if you take your definition that the General Assembly is literally passing judgment on an issue that it really can't, because that's the judicial
the
job.
issue. Could I just follow up on
Sure.
my colleague's questions in this regard? Isn't whether or not the two line up exactly on all fours isn't the issue that the interposition by the General Assembly of 5920 has sufficiently changed the Dunkel landscape that now the defense ought to be able to have the opportunity to educate a jury in this area, given the educability of the jury by the prosecution expert in this area, whether or not the wording of the proffer is exactly the wording of the prosecution proffer under 5920.
Yes, I mean, and what it sounds like we're talking about is a due process claim. There's an uneven playing field created by 5920.
No, 5920 specifically provides that such witnesses can be called by the Commonwealth or defendant. I mean, what we're dealing with are trial courts who are looking at it from a one-sided point of view. The statute itself makes clear that this is evidence that should be coming on both sides.
No, and I 100% agree with you. I was simply saying, based on the conversations the court is having, I think there's a concern from the court's point that 5920 has created constitutional problems in terms of leveling the playing field.
Factual question about this case. The child testified?
Yes.
And was there testimony regarding when the memories became clear? Or, I mean, certainly there was a time frame, when the abuse took place, which was 6 years prior to his testimony. Was there a discussion with the witness of the development of his memory or anything of that nature?
It was pretty straightforward. By the time he testified, I believe he was 12, because by 2018 he was 11. Okay. And there was no real exploration regarding what you're asking.
Was he cross-examined?
He was cross-examined.
And did the cross-examination go to when the memory became clear or when the recollection formed or anything of that nature?
I believe trial counsel Mike Petro addressed those issues, and according to JM, he's had them since he was 5.
Well, and they were consistent, largely consistent with the statements he made contemporaneously when he was 5.
Well, we can revert back to the consistency issue, and they're not consistent. I mean, at least the first two. Now, you have to keep in mind, the first two are not. And again, I summarized his February 11th, 2013. All right, so, they do the interview, the Allegheny County Police watch the forensic interview. They're like, yeah, we're not going to charge.
Well, they declined twice.
Yeah, and this leads me to the second forensic interview is, so mom puts JM into therapy 4 hours a week for the next 8 months, 7 months. Fast forward to late September 2013, mom calls Children's Hospital again, says, you know what, we want to give it another shot. I mean, he's been in therapy 4 hours a week. And again, there's some more startling statements from the summary of that forensic interview. And again, this one happened on October 2nd. Right, and this is, again, I cut and pasted that summary. It's on page 9 of the opening brief. And the forensic interviewer summarized it and said, the following. JM still couldn't identify his date of birth. JM, quote, did not demonstrate an ability to differentiate between real and unreal. JM, quote, was not resistant to suggestibility. Now, this is what JM reported now. He said, defendant hurt his butt with his penis one time. And more importantly, he said this is sometime after Christmas and after his birthday. And that's significant because his birthday is June 24th, 2007. Okay? And the last time Mr. McGinnis saw his son was in June of 2012. And so right around his 5th birthday. Right? So we know it couldn't have happened after that. Right? And so if anything happened, it happened when he was 4, which you're really at the end of that spectrum as to when children can form and create memories, or more importantly, how cognitive psychologists would put it, it's at that age where, taint can really happen, where
Well,
suggestibility.
but you're assuming that when the child said after my birthday, after Christmas, that he knew what months he was talking about. He may have been 5, right? You're making that jump that.
No, I'm not. I mean, no, his
alleged
birthday.
victimization was when he was 4.
No, I'm telling you, the last time Ricky saw his son was June of 2012.
When he was 5.
He turned 5 in June of 2012.
Okay.
That's my point. So if he's talking about Christmas, it has to be the Christmas of 2011 when he was 4.
I understand.
That's my point. If that's a significant fact. So you have the forensic interviewer saying, here's a child that can't differentiate between real and unreal. He still doesn't know his age. He's not resistant to suggestibility. And okay, he mentions one time with being anally raped. And again, the Allegheny County Police Department did not charge. And so what happens is he goes into 5 years of cognitive behavioral trauma therapy. And fast forward to June 2018, mom calls up Children's Hospital again. And if you look at his third narrative, it's very concise, sequential. And again, the third forensic interview happened on July 24, 2018. JM says he reported one incident of anal sex. He recalls watching TV at his dad's house. And when he's watching TV, Ricky supposedly called him into his bedroom, Ricky's bedroom. At which point, Mr. McGinnis pulled down JM's pants and proceeded to anally rape him. And the Allegheny County Police said, okay. And that's why we're here today. And again, this all goes back to relevance, and it all goes back to the issue of an uncorroborated memory and consistency. I don't think they're consistent. They're consistent with what he said. I'll put it to you this way. What he provided at his third forensic interview is consistent with his trial testimony. Right? But that's the question. The whole question was, is that memory after 5 years of therapy, well, more than 5 really, because he was doing therapy throughout 2013 too. And is that a memory based on a real event, or is that something that mom, and this is where we have to talk about mom, because if you look at the cognitive research on this, mom had sole custody of him. Mom unilaterally terminated JM's relationship with Mr. McGinnis because, again, there's varying reasons according to her, but the initial one was because she found a naked picture on Mr. McGinnis' cell phone, and thereafter she unilaterally terminated that. But, if you look at her statements, in her initial statement in January of 2013, she gives this narrative. Like, they're at home one night, and JM spontaneously says, Dad put a hole in my butt. Okay, so spontaneity, right, that sort of adds credibility, like mom wasn't probing, mom wasn't doing this. But if you look at what she said in 2018, it's completely different. And trial counsel did, I think, an excellent job in the pre-trial pleadings. There, particular pleading where he filed a brief in support of his omnibus pre-trial motion regarding taint and competency. I believe it's reproduced record 25 to 34. And in there, he really chronicles mom's statements. And
Counsel, can I interrupt for a minute
sure,
for a second? You mentioned the taint.
Yeah.
So why doesn't Delbridge apply here, and all of these issues should have been resolved through the taint hearing?
Delbridge, well, the question presented is the admissibility to try. Delbridge is a competency. I think Delbridge answers the question because in Delbridge, the court said it accepted the concept of taint. And the way Delbridge 1 defined taint is the implementation of false memories or the distortion of an actual memory. So if you accept that concept, you accept the fact that children can and do create false memories.
You don't read Delbridge as requiring the memory issue to be tested purely at the taint hearing. It can be tested at either place.
No, I briefed Delbridge because, for several reasons. One, there's some good language in there about children and suggestibility. Two, just the concurrence cited Delbridge to say that this is not novel scientific evidence where we need a Fry hearing, and it's cited specifically to this court's opinion in Delbridge 1. But no, I agree. Delbridge is a pre-trial competency issue. What we're talking about is, okay, let's say he's competent and JM is testifying. What can I do as a defendant to raise reasonable doubt with expert testimony to educate the jury about the creation of false and distorted memories? So that's
not in this child, just in general.
In general, yeah. I mean, that's what trial.
As opposed to a competency hearing, which would go specifically to this child. Your desire was to follow the track of 5920 and provide information to the jury to educate it on how victim responses can be manipulated under certain circumstances. Not necessarily these circumstances, but how they can be manipulated.
Yes, a trial counsel specifically filed a motion in support of Dr. Chambers' testimony. That was his basic argument. It's like, look, the Commonwealth is going to present Janie Mesmer under 5920, and for these reasons, he specifically made the constitutional issue of, presenting a complete and full defense and rebutting the state's evidence. So, yes.
Cooley, if this kind of evidence is allowed, if this kind of expert testimony is allowed, would you agree that it's not in every case that there'd have to be some threshold determination that this kind of expert testimony is even relevant in a particular case?
Oh, I agree 100%. And I would refer to Your Honor's opinion in Walker, where, that was the big issue in Walker. The Commonwealth made a number of arguments as to, impacting a lot of cases because a lot of cases involve eyewitness. But, what the court did in Walker is said, okay, there has to be some sort of proffer made to the trial court. Explain to me why it's relevant. Okay, most notably, is it beyond the knowledge of the average juror, and how will it assist jurors in understanding the evidence or making some sort of factual determination? And what are the qualifications of your expert? And so, yeah, there would be some sort of on-the-record proffer where the trial court would be the gatekeeper, so to speak.
Okay, thank you. Any other questions for Mr. Cooley?
This might be a little bit far afield, but would it require in every case a Fry hearing, or is the Fry hearing subsumed under 5920? If you know.
I'll put it to you this way. It depends. I'll give you a hypothetical. Say the Commonwealth is not introducing a 5920 expert, right? Then you would still have to have a on-the-record, colloquy, proffer. But my argument is, it's generally accepted. It would be on the Commonwealth's burden. I briefed this in the reply brief. And the Commonwealth's whole argument, really, if you read the briefs, is that Mr. McGinnis had the burden of production and persuasion at the trial court. I simply disagree with that. The principles that this expert testimony is relying on has been accepted for years. I think Walker established that. And so there is a mechanism in place through the Fry process where if there's disagreement amongst experts, we can have a Fry hearing. But, if you look at what the Commonwealth did at the trial, their whole argument is like, well, we've never heard of this. It must be novel. So they didn't present any evidence of what they presented, in their amicus brief, where the amicus brief on the Commonwealth's behalf is simply, there is some sort of dispute, but I would, as I plead, it's well written, but they didn't cite a single case across the country that said, like what this court ruled in Delbridge or all these other courts held, where it accepted, specifically the admissibility of false memories testimony or testimony regarding what variables, techniques, or communications can produce a false memory.
Okay, thank you, Mr. Cooley. I
Thank
think
you.
we've
Thank
got
you.
it. Nice job. Mr. Vernaccio?
Good afternoon, Your Honors. May it please the Court, I'm Daniel Vernaccio on behalf of the Commonwealth of Pennsylvania from the Allegheny County DA's office representing the Appellee. I'd like to start, if I could, by sort of framing the case and drilling down to exactly why we're here, because to hear Appellant tell it, we are here because the Commonwealth tendered an expert and he, the defendant, now Appellant, sought to rebut that expert, and the trial court considered his request on the merits and denied it for some arbitrary or otherwise reason. And I don't think that that's I don't think that's what happened. I don't think that's accurate. So I'd like to just very briefly say that, first of all, the primary reason why the trial court denied Appellant's request to present his expert is because he never followed through. And this is the point that I was making about Appellant never following through, Appellant not producing what the trial court asks of him. If I could, it's very brief. It's just one paragraph, but it's this page 29 of one of the pretrial motions hearing transcripts. The court asks, or the court, after the defense has tendered his expert, I would need a curriculum vitae. I would need to, after stating that she had never heard of this kind of testimony. Has he been qualified? Has he been subject to a Fry hearing or not? And if so, whether his testimony has been determined by any other court in this Commonwealth to be generally accepted scientific information. And if you can provide that and it's clear on its face, then maybe the Commonwealth would concede the issue. But at this point, I am not familiar with that kind of testimony in Allegheny County in the Commonwealth, which doesn't mean it hasn't happened. It's just not that something I've ever seen or heard of.
Share with me in the statute the requirements or request of Her Honor I should say, the discussion by the trial judge are required in B1 of the statute. Where does it say the CV must be done, that they have to be generally accepted? It's not in the statute.
Your Honor, I read the statute as requiring the witness to be qualified as an expert, which would include under 702, I think it is. But more broadly, I think we just disagree about whether or not that statute is even implicated with the type of expert.
You're indicating that the rule should trump the statute. See, the way this is the specific issue that I have. This is the General Assembly amended. Let's begin with the history. 5920 became effective in 2012 and was amended by the General Assembly July 30th of 21. Recent amendment. As discussed by Justice Weck. In that recent amendment, it specifically lays out the qualifications and use of an expert. And it said, in a criminal proceeding, a witness may be qualified by the court if the witness has specialized knowledge beyond that possessed by the average layperson based upon the witness's experience with specialized training or education in criminal justice, behavioral science, or victim services issues related to sexual violence. And that witness may testify to facts and opinions regarding specific types of victim responses and victims' behavior. 703, a court-created rule specifically in 702C, specifically says the expert methodology is generally accepted in the relevant field. The way I see it, the trial judge disqualified or precluded a witness based upon a rule and never considered any of the criteria outlined in the statute. And so I guess, are you in support, or you are in support of the trial judge's position of ignoring the requirements of the statute, that being 2B1? for purposes of 703 rule.
I don't believe that the trial judge ignored any part of the statute.
Could you please reread what she said, why she disqualified the witness?
She disqualified the witness because, first of all,
Because it's never been done in Allegheny County. Is that a basis? See, you don't need to have a prior designation of an expert. The statute permits the judge to determine if that person is qualified after there's evidence. I guess you could have held a hearing. I'm just really somewhat troubled by the language that you cite in support of your case flies in direct conflict with the qualifications as required by the statute.
a couple of things, Your Honor. First, I guess I just don't see the statute and the rule as in conflict. I think they sort of work in harmony. But even if, say, assume that the statute does trump the rule and there is no such prior requirement, the trial judge also made its ruling based on the factual proffer of what this expert would testify to, that the statute 5920 requires that the expert be testifying as to victim responses to sexual violence, which is not, it's just simply not what the tendered expert in this case was going to be tendered to testify to.
May I also ask, in follow-up to Justice Doherty's question, even if there's a statute, even though there's a statute and in other areas there's a rule that says expert testimony can be presented on A, B, and C, you still have the fundamental rules of trial that the expert has to produce his or her CV, subject him or herself to voir dire, and be established and declared to be an expert by the trial judge. Nothing in the statute changed that, did it?
That's how I read it. I guess even until argument, I never considered the possibility that the statute so totally trumps the rule that you no longer have to.
Then share with us, why would the General Assembly specifically make a statute captioned a criminal proceeding for an offense under 18 Pennsylvania Consolidated Chapter 31, parenthesis, related to sexual offense, close parenthesis. See, I understand the Chief Justice's position, but that's when there are experts being introduced for non-sexual offense cases, and that's when that stuff's required. But again, if the General Assembly would have required that, it would have been written into the statute. So the question I have is, share with me, where do you incorporate the requirement of a CV in a Fry hearing based upon the plain language of this statute?
The plain language of the statute, I don't think, is exclusive. And again, leaving aside the fact that under the factual proffer, I don't think the testimony at all, regardless of a Fry hearing, falls under this statute. But assuming that it did, I don't read the language of this statute to specifically exclude any requirements that the witness actually be an expert.
Can I follow up on that, Counsel?
Yes.
So, you have Dunkel, and then along comes 5920 and Walker. So now you have our decision in Walker doing away with the per se inadmissibility rule, and you have 5920 allowing this kind of bolstering. How can you maintain that in the wake of those two developments, we should continue to insist on this per se inadmissibility of the proffered Chambers testimony that the trial court enforced here? Isn't the landscape substantially different all these years later?
Not necessarily. And I think the first point I want to make is I agree. I would believe it was you, Justice Donahue, who said that the 5920, by my reading of it, is bipartisan. It applies to either party, whether it's the Commonwealth or the defense tendering the expert. I don't see any language in there or in any of the Dunkel case law that specifically limits this to only the Commonwealth may introduce this kind of testimony. As to Walker, I think my general response to that is the same that I would have to all of Appellant's arguments by analogy to the case law, which is that the only thing that these things have in common is that they are generally related to memory. I think Appellant draws far too broad of an umbrella when he says, you know, for example, in Walker, where they're talking about stranger eyewitness identification, the focus on the weapon effect, and in this case, for example, where we talk about suggestive interview techniques and biased interviewers, that these are all fundamentally the same thing, that are all fundamentally supported by the same science. And I don't think that's true. It does appear, for example, that in Walker, the science is well established as to the reliability of eyewitness identifications, but that is not the same thing as saying that the science is equally as well established in this kind of context. And so,
how many decisions have to be rendered in other jurisdictions before we say it's sufficiently well established to at least get a Fry hearing? I mean, bearing in mind this is a PhD who's testified hundreds of times compared to is she a master's? Does she have a master's?
Master's social work.
So how many states have to find that this meets the Fry standard before we'll even allow it to get a Fry hearing in our courts?
I don't think that any number of states. I mean, if a litigant wants to present an expert and there's some dispute as to the science, they're entitled to a Fry hearing to sort this out.
They didn't get a Fry hearing here.
They didn't get a Fry hearing, which was the point that I started out with, which is he didn't get a Fry hearing because the court's. I disagree that the court is denying his request to present his expert. The court is saying, I've never heard of that. Tell me about it. Where has he been admitted? Is there case law? And Appellant, that's the part of the argument that Appellant never followed up.
That seems like a bit of a rope-a-dope here, counsel. Isn't it true that defense submitted a letter to the assistant DA in the case with the resume of Dr. Chambers? I mean, was there any serious basis for suspecting that Chambers wasn't who the defense said he was?
First of all, the trial court maintained in its order denying the defense's proffer and also in its trial court opinion that it never received a CV despite asking for one.
Did it receive a report? Did the trial court receive?
It received what Appellant characterized as a report. It was kind of bare bones, and Judge Bowes, in her concurrence in the Superior Court, homed in on that. It was not a list of conclusions or opinions that the expert would testify to. It was a list of topics. He would talk about.
Very similar to Ms. Messier, right? Isn't it identical to what?
I don't think that's identical at all. No, I think Ms. Messer submitted a report that contained her opinions, that contained her conclusions.
Bullet points. I think we've seen those before.
Many times. The same
more than once from Ms. Messer in this courtroom. Not in this courtroom, in that courtroom. I mean, it's de rigueur, isn't it?
This is obviously not part of the record, but yes, my understanding is Ms. Messer is called frequently in that courtroom, yes.
With those general boilerplate points.
I wouldn't characterize them as boilerplate, but I would imagine that she does, in fact, reuse the same expert.
Let me ask you one more thing on reports. I saw that these allegations started to be made at the age of 5 or so, and then the police twice declined charges, and so the child was sent back for more intensive therapy and went to Glade Run and Mercy Behavioral Health. They're pretty serious facilities and interventions. In all these years, there was never a psych eval done or ordered?
I don't know. I can't answer that one way or the other. And even if I did know, as far as I'm aware, other than what was sort of generated as a result of the therapy, but I'm not aware.
Can I go back to the 5920 real quick and just ask a question about the circumstances and how that would work? Let's say you do have a late disclosure from a victim, and the Commonwealth of Pennsylvania wants to present a 5920 expert that says late disclosures are very common for sexual abuse victims for all these reasons. It's a very common type of a thing. And this, late disclosures of 5, 10, 15, 20, 30 years are not at all uncommon. You get an expert testimony on that. That you would agree would be a proper 5920 expert?
Yes, so long as the testimony is a result of, or can be fairly characterized as the impact of sexual violence, so long as, yes.
Okay. What if in response the defendant comes forward with a contra expert that says, oh no, I have worked with victims of sexual violence for a long time, and I disagree with the Commonwealth's expert, particularly of abuse of a nature of why, very generic. I completely disagree, and a delay in reporting of X years, 5 years, 10 years down the road is not at all common. That would be in a proper 5920.
That would be appropriate under I think that would be appropriate under 5920. That's the exact kind of thing that 5920 contemplates. That there are, when we, the Commonwealth, offer an expert saying there is no normal way that a child discloses abuse, the defense is perfectly entitled to call their expert to say, no, there actually are significant ways that children act, and, you know, the implication being, of course, that although the expert would not be able to opine specifically as to the victim, the jury would hear that these are inconsistent with what the victim had actually done.
Okay.
Chief, just one follow-up on Justice Brobson's. Is it slicing the salami too thin or making too fine a distinction to say that 5920 allows testimony along the Messer lines here, general victim response, etc., in accordance with the statute, and at the same time to say that suggestible behavior on the part of that same alleged victim is per se inadmissible? Is that a supportable distinction in the criminal law?
I think it should be considered to be per se admissible, at least under the statute.
Per se inadmissible.
Inadmissible, at least under the statute, because, again, I just don't, and the Commonwealth does not see the statute as covering the impact of questioning or leading questioning or browbeating or whatever you would like to say by adults afterwards. The statute contemplates the impact of sexual violence, not what happens in therapy or with the mother years later.
Can I just,
Yes.
but what if the testimony was, in my experience, the delayed memories in alleged victims of sexual abuse are the result of therapy that takes place and those memories are implanted, based on my experience?
So again, I just don't think that falls. This does not necessarily mean that this expert testimony is inadmissible at, say, a pretrial taint hearing, like under Delbridge, but under 5920, even couching it in terms of in my experience, the hypothetical expert is still talking about the effects of the interviewer, the child being interviewed, not the effects of the child being sexually victimized.
Okay, I think we've got it. I think we've got it. You both did an excellent job. Thank you very much. Mr. Minner?